This meeting is being recorded.
Good morning, everybody. My name is Chief Judge Albert Diaz, and on behalf of my colleagues on the United States Court of Appeals for the Fourth Circuit, I want to welcome all of you to this appellate practice webinar. I think you all are in for a real treat. We have an outstanding program, chock full of varied and important tips and advice on effective advocacy before our court. Before we begin, I just want to thank all of the panelists who have given of their time to be with us this morning, as well as all of those who work so tirelessly behind the scenes to make this program a reality. My job is easy this morning. It's to welcome all of you and get out of the way and turn the program over to our wonderful host, Nicole Grady. Nikki is a career law clerk to my dear friend and colleague, U.S. Circuit Judge Paul Niemeyer. She graduated from the University of Virginia in 2008 with honors, and before clerking for Judge Niemeyer, she was a district court clerk for Judge T.S. Ellis in the Eastern District of Virginia. So Nikki, thank you for being our host, and take it away.
Thank you so much, Chief Judge Diaz. As the Chief Judge mentioned, we have an incredible lineup of speakers this morning and are delighted to have all of you joining us. I have just 3 quick points to mention before we begin. First, we'd like to make this as interactive as possible, so please submit questions using the Zoom's question and answer feature, and our panelists will then do their best to address those questions as time permits. Second, it's really important that those participants seeking CLE credit respond to poll questions that will be sent to you during the program so that we may verify your attendance in accordance with state CLE requirements. We currently do not have state bar information for a fairly large number of participants, and without that information, we'll be unable to certify your attendance with the appropriate state bar. You'll have another opportunity to provide this information, though, when the poll questions appear. So even if you provided it when you registered for the webinar, please provide the name of the state or states where you will be seeking CLE credit, as well as your bar number if you have that readily available. We will be providing attendance records directly to North Carolina, South Carolina, and West Virginia, and we will email you an attendance certificate for you to provide to Virginia. For all other states, it'll be necessary for you to self-submit. And finally, if you experience any technical difficulties during the program, you can request assistance from a member of our IT team by sending an email to 4cca-training@ca4.uscourts.gov. With those preliminaries behind us, I would now like to welcome the members of our first panel to join me on screen. Our first panel, A Conversation with the Solicitor General, is being moderated by the Honorable Toby J. Heitens. In addition to leading this panel, Judge Heitens has been really instrumental in putting this entire program together, a role for which he is uniquely well suited. Before joining the Fourth Circuit in 2021, Judge Heitens was himself an accomplished appellate advocate. Immediately prior to his appointment, he served as the Solicitor General of Virginia, during which time he argued cases before the U.S. Supreme Court and also oversaw that office's representation of Virginia before our court. In addition, earlier in his career, Judge Heitens also spent time serving as an assistant to the Solicitor General in the U.S. Solicitor General's office. What really sets Judge Heitens apart for purposes this morning is that he combines these and other experiences as an accomplished appellate advocate with a true love for teaching and sharing his knowledge with others. He spent 8 years as a popular and award-winning faculty member at the University of Virginia School of Law. And as if that weren't enough, he also helped lead both the law school's Supreme Court litigation clinic and coached the undergraduate trial advocacy team. Judge Heitens, it's a pleasure to turn the floor over to you.
All right. Well, thanks very much, Nikki. And I'd like to thank our guests for being here this morning. We know you have an extremely busy schedule, and I'm really looking forward to the conversation. You may have noticed so far, no one has actually said your last name, because when I told people I was going to interview you, one of the most common questions I got was, could you please ask her how she pronounces her last name? Because there seems to be some confusion about that.
Well, thanks for starting with a softball question. That's an easy one for me to answer. It's pronounced pre-logger, as in before the logger.
That's easy to remember now that you put it that way. Well, thank you so much again for being here. And I just want to dive right in because I suspect a lot of people who are participating have some familiarity with your job and the office that you lead, but I also suspect a lot of people don't necessarily. So let me just start off by asking, how would you describe the mission of the Office of the Solicitor General?
So the Solicitor General's office within the Department of Justice is charged with managing and supervising all of the Supreme Court litigation on behalf of the federal government. And I think that's our most quintessential role and duty, but it's really the most public-facing aspect of the work, and by no means the kind of sum total of what we do within the office. More broadly, we're also responsible for supervising the appellate litigation strategy of the federal government, kind of across the range of cases, throughout the country, handled by U.S. attorneys' offices in the first instance, or by the litigating components, or by agencies themselves. And I think that is also an important part of the mission, to try to ensure that we have consistency in the positions we're taking and in our role in trying to advance the interests of the United States in court.
So how many people do all of that? How big is your staff, both in terms of lawyers and then non-lawyer support staff as well?
We are relatively small for a component in DOJ. We have about 55 people on staff. It's about half and half lawyers and support staff. We have a wonderful case management team, paralegals in our research and publications unit, and administrative staff. And then we have about 27 lawyers in the office at any given time, including our 5 Bristow Fellows, which is this fantastic opportunity, usually for recent law clerks who are coming off their clerkships, to come to the office for 1 year and assist us with work. And then we have 22 attorneys, counting me, 5 deputies, and 16 assistants to the Solicitor General.
And so you're obviously a political appointee. How many other political appointees are there in the office?
There's only one other political appointee. The Principal Deputy Solicitor General is also appointed, but that means that there's a lot of consistency in terms of who's in the office at any given point in time. The other 4 deputies, for example, are longtime career officials at the Department of Justice. Some of them have been in our office for decades. Some are relatively newer, but it's a really nice way to ensure that we've built up some institutional knowledge. And then the assistants as well stay for varying amounts of time, but we have some who have stayed on for many, many years, which is really wonderful too.
And how many cases would you say? I realize in some sense, your involvement in different cases is, you have lots of different kinds of involvement in cases. So maybe just focus on the cases where your office is taking the lead. How many cases of that category would you say that you're working on at any given time?
So the cases in which we are taking the lead are the cases in the Supreme Court. And it's the cases, of course, that we're handling at the merits stage. We are the most repeat player in the Supreme Court. We tend to participate in, these days, usually over 80% or higher of the cases that the court hears each term. And in a substantial number of those, we're a party. And so, maybe it's a criminal prosecution that's come all the way up to the court. Maybe it's a case involving a signature policy, an agency that's been sued to challenge that policy. And that's about half of the cases in which we participate. But the other half of the cases in which we come in, we're an amicus, and we're participating as a friend of the court because the issues in the case have the potential to affect the interests of the United States. It's not surprising that many legal issues before the Supreme Court have those kinds of wide-ranging impacts. So I would say at any given time, we have merits briefing going on in a substantial number of the cases that the court is hearing. When the court's in session as well, we're frequently participating in oral argument. And so between October and April, for those 7 months, we have regular arguments happening. And it's a really wonderful tradition in the office that we all help each other prepare for arguments with moot courts. We try to attend each other's arguments. And so, we're watching with interest as those cases go to their final resolution. So that's the merits work, but there's also a substantial amount of cert stage work that our office is participating in. It's hard to put a number on it because it really just varies depending on what's happening in the lower courts and how frequently cases are being decided there. But we are, at any given time, lawyers in the office are usually in the position of trying to oppose Supreme Court review and defend our victories in the lower courts in a much smaller number of cases were the ones actually seeking to invoke the court's cert jurisdiction.
And so, there's no way to even ask this question these days without having to take sides on a dispute between what you call something. What percentage of your cases would you say involve either what some would call the shadow docket or what some would call the emergency docket?
So, this has been a real shift in Supreme Court practice, really within the last decade or so. I had worked in the SG's office for a number of years as a career attorney, as an assistant to the Solicitor General. That's the line attorney in our office. And the entire time I was in the office previously, and I don't know, Judge Heidens, about when you were in the office previously, but I didn't have a single case on the emergency docket. I had never, had to write a brief overnight or on a 24-hour clock. And so it's been really just in the last 10 years or so that docket has become a much more substantial part of the court's work and a much more substantial part of our work accordingly. Sometimes it's quiet and we haven't had an emergency case in a while. Sometimes I feel like we have 3 or 4 going at once. We are sometimes in the position of seeking the court's relief on that docket, particularly in instances maybe where we're facing a nationwide injunction or some other kind of universal remedy that a district judge has entered that we think is erroneous, but we haven't been able to get relief from the relevant court of appeals. So we have to take it to the Supreme Court and ask for the court to step in. We're also not uncommonly in the position of opposing emergency relief when the litigants on the other side are themselves invoking the court's docket. So it has really changed the nature of the work in the office. We try to spread that work around because it is high stakes and intense, and it can often lead to multiple briefs that need to be filed on a very short time frame. And so each of the assistants kind of takes their turn in working on these matters. But it's a really kind of different aspect of Supreme Court practice that's a relatively recent shift. And the other little piece of this is that the court itself, I think, has changed some of its practices with respect to the emergency docket. And in particular, some of the justices have talked publicly about how that docket leads to the need to make very important decisions on important issues with high stakes for the nation, often in a rushed posture without the full opportunity for briefing and argument. And the court has, in a number of cases recently, instead of resolving an issue on the emergency docket, decided to instead grant review in the case and schedule it for argument in an upcoming sitting. And often, if it's granting cert before judgment, there'll be a full round of briefing leading up to that. And so I think it demonstrates that the court itself has been adjusting its practices to try to make sure that with respect to those issues that are coming up in that kind of posture, there's the opportunity to have a greater opportunity for deliberation and process in those cases.
So this is a totally my bad, and in many respects, I think your answer may have already answered this question, but we got a great question from the audience asking, what is the shadow docket / emergency docket? And as I said, I think your answer probably touched on that, but could you just, for the benefit of folks who aren't familiar, give a sort of capsule summary of the question that I introduced poorly?
Yes, of course. So the court's traditional merit docket is when the court grants review in a case off of a cert petition, and then here's the case in the upcoming term, often with lengthy periods for briefing, 45 days to file an opening brief for the petitioner, 30 days for the respondent, and a reply brief. So those cases are unfolding on a multi-month timeline, and the court often takes months to issue its decision. The emergency docket exists for when a party needs to come to the court to ask for a form of extraordinary relief, typically asking for a stay of a lower court order, sometimes more rarely asking the court to issue some kind of preliminary relief like an injunction in the first instance. And the docket exists and has long existed for purposes of providing a forum or a way to seek that kind of form of redress, usually pending appeal or pending further proceedings in the case. And so this often comes up in a preliminary injunction posture or other posture like that. And the thing that has been unique or a shift in practice in recent years has been, and I tie it to the rise in universal remedies and nationwide injunctions, has been the number of parties and litigants who have come to the court in this posture, asking the court to step in at that early stage of the case. But usually there's an agency action that's about to take effect, or some other relevant thing happening in the world that prompts the need for a quick resolution. And so those cases tend to unfold on a much more rapid timeline, often with just briefing, no argument, although the court has, in a handful of cases in recent terms, actually heard oral argument for an emergency application for purposes of resolving it. We have one of those coming up in February, where there was a filing on the emergency docket, and the court decided to hear argument on that case.
Yeah, and it's definitely been a shift. So I was in the office from 2007 until 2010, and I think I did two, and I think they were both stays of removal. So my sense is that until recently, they were overwhelmingly either capital cases or stays of removal, and that the shift is that they're not remotely limited to that.
Yes, I mean, and going back, thinking back to when I clerked on the court, and there, as law clerks, you're seeing all of the cases that come into the court on the emergency docket. They were almost exclusively capital cases when I was a law clerk. So you're right, that often, anytime an execution is about to occur, there's a lot of last minute filings to try to resolve legal issues before that can happen. But what's happened in recent terms has been adjudication of agency policies or other issues like that on the emergency docket.
Great. So you probably get asked, I suspect, most often about your office's work before the Supreme Court. But as you know, this is a Fourth Circuit seminar. So I wanted to ask some questions about the work in front of the Court of Appeals, and some questions that people who work within our court or practice before our court may have encountered. So as you mentioned, I think, I don't have precise numbers, but it seems to me that the overwhelmingly most common way on the Court of Appeals we see the federal government or an agency appearing is as an appellate. So what involvement does your office have in those cases, the ones we see where the government is bottom side or the red brief, as it were?
So in those cases, my office often will not have a touch point in the case. It's hard to generalize across the board because there are certain cases where we are monitoring it from the outset. Sometimes, for example, even before litigation is filed, or if it's affirmative litigation that the department's bringing on behalf of the United States, we'll have a pretty good sense that it's going to go all the way up to the Supreme Court. And so we will try to get involved at an earlier stage in the case and help to craft the legal strategy and the legal arguments. And I really welcome those chances as an appellate attorney to get involved early and make sure that we're preserving the arguments and advancing the arguments we'll want to adhere to later in the litigation. But in the traditional case where the United States is bottom side, those are handled across the U.S. attorney's offices throughout the country. They're often handled by litigating components in the first instance. And I would say in the mine run case like that, we are not actually seeing that case or being looped in on it unless there's a reason to think that it's going to require SG office approval at a further, kind of decision point in the case. So, that means that we are trying to get a grasp of the range of issues in which appellate litigation is happening on behalf of the federal government, but we're usually doing it in a circumstance where we're the appellant rather than the appellee.
So now, what about every once in a while, I've been on a couple panels that were like this, every once in a while we get the briefing is done, and then we get a follow-up letter saying essentially, having thought about it more, it is now the view of the United States that X. Could you talk to me about what those letters are, how they come about, what involvement, if any, you have in those?
Sure. So, hopefully those letters come about relatively infrequently. Obviously, our goal is always to get it right the first time and to come to the courts of appeals with a well-developed position on behalf of the United States. But in the circumstances where you might see a letter like that, what has usually happened is that another case has percolated up to my office and presented a decision point about what position to take, often in another district or with respect to other litigation. And I've had to make a call, sometimes recognizing that we haven't been taking consistent positions across the country on what the position of the United States will be. And once the SG's office resolves that, I kind of formally sign a slip that basically determines for the office and for the department, and therefore for all of the litigating components, what the federal government's position on an issue is. We'll take stock of whether there are pending cases that stand to be affected by the resolution of that issue. And then we come to the courts and we explain what our position is to make sure that we're now advancing the consistent view across the range of cases that are affected.
Okay, let's shift gears from the more common case where the government is the appellate to the cases where the government is the appellant. What does the process look like in those cases?
So in those cases, my office plays a substantial role. And I think that you had mentioned that, people tend to be most familiar with the SG's office as it relates to Supreme Court litigation. And that's certainly the most public facing thing that we do because we're regularly in the court briefing and arguing those cases. But one of the really important functions or roles of the SG's office is what we call the appeal authorization process. And the Solicitor General is responsible anytime the federal government has lost on a legal issue in a lower court and review is sought or further review, there's an interest in appealing or having further review, it requires the personal authorization of the Solicitor General to continue to advance the litigation. And the idea behind this is to have a centralized process where issues and appellate decision points are funneled to our office, in part for what we were discussing earlier, to make sure that we're taking consistent positions, in part to make sure that we're getting eyes on the nature of the legal issues and ensuring that we think further review is going to actually advance the interests of the United States, and in part to kind of think through the resource issue and whether further litigation of that issue is worth the investment of time and resources it will take to appeal. So what that means, just to try to make this a little more concrete, is that anytime there's an adverse district court decision, let's just take the example of a federal criminal case where a suppression motion is granted. If the trial team in that case, the U.S. Attorney's Office, wants to appeal, they have to seek my authorization. So they write a memorandum to me, a recommendation memo, where they outline the issues in the case, what happened below, and then outline the case for appeal and why they think it would be in the interest of the United States to appeal. Maybe they'll say, this evidence that was suppressed is critically important to our prosecution. And we think that, without this evidence, the prosecution is going to be substantially impaired. Then any other component of the federal government or litigating division has a chance to weigh in on the very same case. So in this example, it would go to our criminal division, and lawyers in the criminal division would take a look at it, and they would likewise write a recommendation to me explaining whether they think that we should take an appeal. In a criminal case, it might just be CRIM and the U.S. Attorney's Office. In other cases, you can imagine situations where we have a wide range of agencies or divisions that are interested, and all of them will have a chance to provide that kind of input. Then it comes to the SG's office, and it's assigned to one of our assistants, a line attorney, who will take another look at it and write a recommendation. It'll go to the relevant deputy who has a kind of specialized docket. He'll write a recommendation, and finally the packet makes its way to me, and I review all of the materials. We used to do this by paper. The packets would be like this high. Now we do it all electronically. But I have to ultimately make the call on whether to authorize that appeal. And sometimes it's easy. The recommendations are uniform. Clearly, we have a good legal argument, and it's in our interest to appeal. But you would be surprised at the number of situations where the recommendations are divided. One of the things that we're thinking through in these cases might be whether we have a good chance of success on appeal, or whether we're actually risking taking a bad district court decision and turning it into a binding bad circuit court decision. So we kind of factor in to the analysis all of those relevant considerations about whether we think an appeal would actually advance our interests. And then I ultimately have to make the call on whether to authorize it. So if you are seeing a government appeal and we're filing the blue brief in the case, it means we have run that process behind the scenes, and I've affirmatively authorized that appeal and decided that it's in the interest of the United States to go forward.
And how much guidance, there's the bottom line, do we do this, do we not do this? But I guess there's all kinds of tactics. Assuming the answer is not, we're not doing this at all, there's all kinds of further sort of tactical decisions. How far do you get into those beyond the, are we appealing, are we not appealing?
Yeah, so we really do get into those. Sometimes I'll authorize an appeal with respect to certain issues, but not others. And so we'll be selective in which issues we decide to take up. Once the attorneys in my office have read into the case, they often have, I think, really helpful ideas about how to brief the issues or about how to shape the course of the appeal. And so they'll frequently review draft briefs and offer suggestions or edits. OSG does not personally handle those appeals, and so we are not going to be the lawyers in the first instance who are writing the briefs for the most part, or who are presenting the arguments in the courts of appeals. But we often try to collaborate with our DOJ colleagues in ensuring that once we have kind of dug in and formed a view of the issues, we're trying to add value in making the appeal as likely to succeed as possible.
So I guess the last place that on our court, we see the federal government at the panel stage is as an amicus, either the federal government appearing sort of as the United States of America, or we see some federal agency appearing in front of us. How if at all does your office get involved in questions like that?
So it's a very similar process. In addition to appeal authorization, it's necessary to get the SG's approval for amicus participation in the mine run case. There are certain contexts where agencies might have some independent litigating authority, but in the substantial majority of cases where you're seeing an amicus brief at that stage in the courts of appeals, it's because we've run that behind the scenes process and I've decided to authorize it. That's true of rehearing en banc as well. It's true of intervention to defend the constitutionality of statutes in the district courts, and also for the cert decision. So we take the same kind of process and we apply it to each of those decision points, and that's true of the amicus work also. There, of course, one of the relevant considerations is that we could easily sit it out altogether. And so I think that as we're kind of thinking through the calculus of whether to come as an amicus, we're always asking ourselves, does the United States have a unique perspective on these issues where our participation will materially aid the court, where we can truly be a friend of the court in its consideration of this legal issue?
So you've mentioned the en banc and the cert stage and said the processes there are generally similar, which makes perfect sense. In terms of what about the standards or the things you're thinking about when making those decisions? Do those differ at all when you move from the appeal question to the en banc question, from the en banc question to the cert question? And if so, how do the considerations change, or how does the standard change?
Yes, so definitely the considerations change, in part because the standards that the courts themselves apply change. You know, when it's the basic question of should we take up this adverse district court decision and go to the Court of Appeals, we'll have an appeal as of right, and we don't always exercise it because maybe we think that it's not worth the investment of resources, or we think that our legal arguments are not particularly strong, so we won't go forward. But we're not factoring in the question of whether it satisfies some standard of appellate criteria. And that changes substantially for rehearing en banc, and especially for cert. We recognize that those are discretionary decisions of courts of appeals and of the Supreme Court. And we want to try to be careful to limit the number of requests we're making only to those where we really think that the standards are satisfied. You know, it's not uncommon for the trial teams who are handling these cases to think that if we've lost, the decision is wrong or unjust. We usually believe in our positions and think that, we're disappointed by an adverse result. But the relevant question for rehearing en banc is not just, do we think the panel got it wrong? It's, do we think that this is an issue of exceptional importance? Is this an issue that involves division among the circuits, where there might be a lot of utility in trying to clarify a circuit split and ask the court en banc to reconsider its precedent if it's an outlier, for example? And then at the cert stage as well, there, I would say our requests are even more limited in number. And the reason for that is because the court itself takes so few cases each term. And we want to be really careful to kind of preserve the moments when we're asking the court to weigh in to those where we think we have a really strong case to make, that there is a circuit split that requires a uniform rule and necessitates Supreme Court review, or where a statute's been declared unconstitutional. The court, regularly weighs in for that. And it kind of goes back to what we were discussing before about just the sheer number of cases my office participates in. We are a repeat player, and so we want to make sure that the court can essentially understand that we ourselves are applying this kind of filter to try to ensure that we're complying with the court's own standards in deciding when to seek cert.
One last question on amicus curiae participation that we got from the audience. Even less commonly, but not never, the federal government occasionally participates in state court litigation as an amicus. I'm personally aware of a case in the Supreme Court of Virginia within the last couple of years. How does that process work? Is it generally the same?
Yes, so it follows the same kind of internal process of soliciting recommendations. And really the decision point on this will turn on the nature of the issue that's being considered by that state court. If it's an issue that really affects federal interests and where we think there's the chance that there'll be an important precedent that's handed down, we'll apply the same lens to the relevant question of whether we should get into that case in order to offer our views.
Right. And then on the cert stage, one question, sort of related question to the seeking cert. As some of our audience may know, sometimes the party that won in the courts of appeals essentially acquiesces in the Supreme Court granting cert. I was thinking back to my own time in your office. I think I recommended seeking cert once, and I recommended acquiescing in cert once. in 3 years. So would you talk a little bit about the acquiescing process and what goes into that, and what sort of considerations you think are relevant there?
Sure. And it's really not that uncommon for us to acquiesce in cert. We're certainly in the, typical case where the other side has sought cert, we'll file a brief in opposition and oppose review. But there are a number of cases each term. I would say in every year that I've served in this role, there have been at least several occasions where there really is a circuit split. That means the federal government has won on the issue in some courts and lost on the issue in other courts. And a lot of times, what's most important to us is to get a final resolution of that issue. And so if the vehicle that's teed up for review is a case where we happen to have won, we'll acquiesce in cert in recognition that the case meets the criteria for review. And even though we're going to defend the particular result in that case, we think it's important for the court to issue a ruling on a particular matter so that we have that kind of uniformity across the country.
So now I'd like to pivot to a topic that is absolutely fascinating to me. I actually got fairly deep into writing a law review article about this topic. I spent a whole bunch of time on it, and then sort of life intervened and it went in a different direction, which is the way that your office gets involved at the cert stage as an amicus curiae. Now, it's my understanding, you can correct me if I'm wrong, but it's my understanding that the federal government, not never, but very, 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 very rarely files an uninvited amicus brief at the cert stage. Not the Pledge of Allegiance case. I believe the federal government, for example, filed an uninvited amicus brief at the cert stage, but it's that kind of case, my sense is, where the federal government does that. But there's this practice that some of our audience probably isn't familiar with, where quite a few times of the year, the Supreme Court issues this weird order in which they say they are inviting you specifically, to file a brief on behalf of the United States in a case to which the federal government is not a party. This is what's sometimes called a CVSG. So could you talk a little bit about that process? It's always framed as an invitation. Do you view that as an invitation that you have a choice about? And how does the process work within your office?
So you're right that it is framed as an invitation, but I personally, and I don't think any former SG has ever turned the invitation down. We really welcome the chance actually to weigh in when the court does this. So you're right that in any given term, this will happen maybe 10 to 20 times throughout the course of the year. The court will issue this on its regular orders list, and will invite our office to weigh in and file an amicus brief at the cert stage, where the court, I think, is often looking for our views on whether the case warrants review, and then, of course, on kind of a preview of what we think is the correct answer on the legal issue presented in the case. And the court generally has, I think, a pretty good reason for doing this. It's usually not a mystery to us why our views have been invited, because in those cases where this tends to happen, the United States is not a party by definition. But usually there's a really clear federal government interest or hook or nexus where, the parties are debating, for example, how the resolution of the legal issue is going to involve something that substantially affects the federal government, or where there's a dispute about a statute or some kind of regulatory program where the federal government is going to have some unique expertise to offer the court about the right way to think about that legal issue. And so we always approach those, very much welcoming the invitation and the opportunity to tell the court what we think about whether the case merits its resources and attention, and also what we think of the lower court's decision in the case or the broader legal issue that's been presented. And for this one, it's somewhat similar to the process I was describing before in terms of collecting views. Normally in the typical case where there's a CVSG, we're going to have a substantial number of different agencies or components or divisions within the federal government that have some kind of stake or interest in the dispute. And the example I always give for this one is, imagine a case that involves the interpretation of Title VII, an employment discrimination case. We will have interest in that as the federal government through our Civil Rights Division, which of course has substantial enforcement side interests in ensuring that there is protection for workers against discrimination in the workplace. The EEOC has deep subject matter expertise in this area and often has a role to play and a perspective to offer on that. And then as well, we are also, as the United States, the nation's largest employer. And so we are sometimes a defendant in Title VII cases, and we're defended by our civil division, which has those kinds of defensive interests. And so if you can imagine the typical Title VII case where maybe we're asked for our views, all of those components and entities are going to have a stake, and their operations will stand to be affected. And so they will take a close look at the case and offer their views and write a recommendation. And a lot of times what we're trying to figure out in the case is the kind of right way to thread the needle and think through, what the appropriate resolution of that legal issue is, taking account of those variety of interests that exist, sometimes in cross-cutting or competing ways.
And so what happens when people don't agree?
So then when people don't agree, I face a tough decision. It's ultimately the responsibility of the Solicitor General to decide what the position of the United States is going to be. And so when I get those kinds of divided recommendations, and sometimes it's not even just on, kind of how to think about the nuances of the legal issue, I might get separate recommendations about which side to support in the case. So it's a difference about the bottom line of how the case should come out. We'll have to really run a careful process. And one of the things I always want to make sure to do is to ensure that I've gathered the relevant information. So we provide a pretty robust opportunity for stakeholders to weigh in. I never want to be making one of these decisions without feeling like every voice was heard. And even if ultimately I can't make everyone happy and someone's going to be disappointed by my decision, that they at least know that I heard what they had to say and took it into account and factored it in. And a lot of times it's a really productive process to try to figure out if there's some common ground or a way to narrow what we're saying in the case to account for the variety of interests across the federal government. People have told me that they think that the bodies are buried in the footnotes of OSG briefs. And a lot of times those footnotes are crafted to carve something out or to say to the court, by the way, there's a different context where it's not directly presented and might implicate different concerns. So whatever you might say about the legal issue here, please don't say anything about this other context. And we might include that kind of footnote specifically because we have a government program or an agency that has an equity in the case that's not directly presented, but could be affected. And we're trying to navigate through those competing interests to come up with kind of the best take on what the position of the federal government or the United States writ large should be. The other thing we're doing, of course, is thinking through the court's own criteria for review. So sometimes we think the Court of Appeals got it wrong. We agree with the petitioner in the case, but we tell the court, this only comes up once in a blue moon. And, if this is going to be one of your 60 cases, we don't think this should be one of your 60 cases this term in light of the limited resources. Or we'll think that a circuit split isn't actually as sharply presented as the parties are making it out to be. So I think one of the reasons the court solicits our view in this circumstance also is just to get the take of another set of eyes on, the representations the parties are making about the cert criteria.
Do you ever get invited to file, or does the federal government ever get invited to file briefs before other courts? And how do you treat those requests? How's that similar or different?
Yes, so we do get those CVSGs from courts of appeals sometimes. A lot of times we'll get these after argument, actually. So, a case will be litigated and then the Court of Appeals after the fact will issue an invitation to my office again for the United States to weigh in on the case. Sometimes this will happen pre-argument. When in the situations where this happens, it's usually not just, coming out of the blue for us. Sometimes we have been monitoring the case, taking a look at it, ourselves even thinking about whether to come in as an amicus. And in this circumstance, I would say when the decision comes to me, there is a thumb on the scale for accepting that invitation and participating in order to help the Court of Appeals in resolving the issue. There have been a handful of cases where we had made a deliberate decision not to participate as an amicus, where we've actually turned down the invitation and declined to submit a brief. But those situations do not come up very often, and we always want to provide help to courts when we can.
Yeah, I can imagine there'd be difficult situations where the federal government doesn't have a position on this, and perhaps the federal government doesn't want to have a position on this.
Exactly, right. Normally in the typical case where we're declining the invitation, it's because it raises really complex issues within the government about what our position should be with some of these cross-cutting equities. And we've decided the best thing is to not commit ourselves to a position at this juncture until we see how the issue is resolved and whether there's going to be further review.
I'd like to pivot to asking a couple of questions sort of about practice and sort of preparation right now. One thing, This only was the case for the very last argument Ira did before the Supreme Court, but it's my understanding they're still doing it, which is, as some of our audience may know, a few years ago, the Supreme Court changed a whole bunch of things about the way they do oral argument. And one of the ones they changed is they decided to give each advocate, and not just give each advocate, but tell advocates they were going to get a sort of certain amount of uninterrupted talk time at the beginning of each of their arguments. How have you found that practice to be? Have you seen any changes in it? And what do you think are the sort of upsides and downsides of not just having a rule like that, but sort of announcing that you have a rule like that?
I think actually that this is a great practice that the court has adopted. The typical Supreme Court argument, as many of the people here probably know, is a hot bench, right? There are a lot of nonstop questions, and the advocate is frequently just, moving from question to question with no opportunity to recenter and to kind of set forth an affirmative view of the case. And so I think having this uninterrupted 2 minutes at the outset of argument is really useful with respect to just setting out kind of the themes and the focal points that the advocate wants to make sure the court has in mind as they start thinking about the issues in the case. And I think a lot of the justices listen carefully to that presentation, in part because they know that the advocate has carefully prepared it and has thought really hard about, what is my 2-minute elevator pitch? If I have this chance and it's my only chance to really have uninterrupted time to make my case, what am I going to say? And a lot of questions often come out of that introductory remarks. Certain justices, Justice Kavanaugh does this a lot, will say, in your intro, you focused on this, or you said this, and it prompts a question for me. So I think it can also be useful in ensuring that the justices are keyed in on that and then have the chance to ask follow-up questions based on the introduction. So I think there's a lot of upside. If I were to identify the downside, the one thing I would say is that the advocates, knowing that they're going to have this opportunity, prepare their remarks in advance, are frequently reading their remarks. And I think just like with anything else, when someone's reading something, it's easier to tune it out, right? It sounds more rehearsed or less natural. There's less give and take in the moment. And so I think that there is, I'm glad that the court limits it to 2 minutes, because I don't think it would be particularly useful to have attorneys reading 5 or 10-minute speeches.
How often do people use less than 2 minutes, and how, if at all, do they signal that they're done?
So I think most advocates use the full 2 minutes, although a handful of times I've witnessed someone come up, make one succinct point, and then the way you signal to the court that you're ready is to say, I welcome the court's questions. I think actually the harder point is when you don't say that, you've used your 2 minutes, and then you're pivoting to something else. There's always a little bit of a moment where the justices, I think, are wondering, should I break in? But then they almost always do.
So I want to take a step back from the argument itself and talk about the process of preparing for the argument. Something that first struck me when I was a Bristow Fellow a long time ago, and that I've taken to every job ever since, is a deep-seated view that there are 2 categories of moot courts in the world. There are the moot courts done in your office, and there are the worst moot courts that are done everywhere in the world that are not your office. So could you just talk for our audience a little bit? You mentioned these moots, but I want to ask you to sort of bear down a little bit more. What's the process of mooting cases in your office? Who's there? What's the moot environment like? Just tell us as much as you can, obviously without getting into the specifics of any case. How does it work?
Yes. So, I obviously am a little biased about this, but I share your view that going through an OSG moot court is a daunting experience, but one of the best ways ever to get prepared for an actual oral argument. We have a longstanding tradition in the office of mooting our colleagues. And so what that means is that anytime anyone in the office has an oral argument coming up, we'll set up 2 moots for that person. The mooters, the panelists on the moot, will be 3 attorneys from the office who are new to the case. Usually the assistants to the SG are the kind of pool of mooters that we draw from. And then inside the room as well will be the entire team that's litigating that matter for OSG, so the relevant deputy and assistant on the case, and then the clients and the stakeholders. So the litigating divisions that handle the case below, the U.S. Attorney's Office, if there was an AUSA team involved, agencies, if they're affected by a particular case, or if it's a case involving agency policies, all of those people will have a chance to participate as well and to listen in on the moot so they can offer feedback for refining the arguments that are made. So you come into our conference room where these moots happen. And I have to say, I am just every time I am so gratified by the amount of preparation that the moot panel does. The assistants who are preparing for the moot really put you through your paces. They read into the case, they read the briefs, they often read some of the amicus briefs, they often look at some of the key Supreme Court precedents that will affect it. And then they are prepared to grill you, usually for an hour or even longer, trying to air out and get on the table all of the relevant types of questions that the court themselves could focus on. And I remember for my very first moot in OSG, I was frankly terrified because my colleagues are brilliant and they are really prepared. And I really didn't want to embarrass myself in front of them and not be ready for this moot court. But it's all in the spirit of just helping the advocate who's going to present the argument feel prepared and to have a chance to try out how you're going to respond to the pressure points in the case and the various vulnerabilities. And then really importantly, to get feedback. You might try out an answer to a hypothetical and that this hypothetical is going to come up at argument because it's the central issue in the case about whether you have a limiting principle. You try it out, and then in the feedback session, the mooters can tell you what worked for them and what didn't. And it's this really effective exercise in getting variety of perspectives and making sure that you're able, therefore, to refine your answer or sharpen it, or try a different approach altogether if it's just not landing and isn't working. So the goal is always to ensure that once you've gone through 2 of these moot courts, you have likely been exposed to the vast majority of questions that the court itself is going to ask you. There are always some that were not predictable, and so we don't necessarily cover the waterfront in getting each and every question out there, but a substantial number of the questions that come up at argument have previously come up in an OSG moot.
So you mentioned these other 3 people who haven't been working on the case, and this sort of picks up on a question that someone from the audience asked, which is about how the sort of workload is divided up in your office. Do people have subject matter specialties? Do you have people who are like the tax people who are the immigration people? How does that work within your office?
So we are all generalists to some degree, especially the assistants to the SG who are our line attorneys. Every assistant to the SG does a bit of criminal work because we have a lot of criminal work in the office. And then it's really a mishmash of different issues that might come up. And I've always thought of this as kind of various dockets or issues that you get attached to, often through the happenstance of having done one case on a matter, and then you're the person who comes to mind for the relevant deputy with respect to the next case. So when I was an assistant to the SG, I did a case that involved a takings claim under the just compensation clause. And once I had done that case, the next time we had a merits case also involving a takings issue, it got assigned to me. And I really liked that because it creates the chance for a little bit of specialization and repeat exposure to different areas. But it's not like all I did day in and day out were takings cases. I had a variety of other matters as well, and I enjoyed that. The deputies are a little more specialized. So we have 5 deputies, and each of them has a docket that involves particular types of issues. If it's a criminal case, that's going to go to Eric Fagan because he's our criminal deputy who handles almost all of the criminal matters. If it's a tax case, that's going to go to Curtis Gannon because he handles tax. Antitrust is handled by Malcolm Stewart, and so on. So the deputies have a little more specialization, but there too, the range of issues just really runs the gamut, and each of the deputies is covering a number of different subject matters and agencies. And so, it never gets boring. There's always something new to work on. And for me in particular, this is actually one of my favorite parts of the job. I'm reviewing all of the work of the office. And so when we file a merits brief, anytime we file a merits brief in the Supreme Court, I have personally reviewed and edited it. And as a result, I'm getting exposure to, the range of cases in which the court is hearing argument and in which we are participating either as a party or as an amicus.
That sounds like a lot. So a question that relates to something that someone has asked is, how do you personally sort of keep up with all of this, all of these decisions of the courts of appeals, all of the things going on in the Supreme Court? This just seems like a Herculean amount of work to have one person do.
It is an incredibly intense job, but the thing that really makes it doable is that I have an incredible team. I am so lucky in that the attorneys in the office are really brilliant lawyers and advocates. They are, just fantastic writers and editors and oral advocates. And so I rely really heavily on the team to get me up to speed. to brief me on cases. The big change for me, because I had been one of these line attorneys for so many years and then went to the private sector for a while and then came back in this role. And the role of the SG is very different. When you're an assistant to the SG and you're writing the brief in the first instance, you roll up your sleeves and you master every jot and tittle of the case. You've read every piece of record evidence. You've read every underlying case. You really need to know it inside and out for purposes of developing the arguments. And I love that because I really like to feel like I have dug in and totally understand a case inside and out. But there's just not time in this role for me to do that with each and every case. And so I have to take a much broader view of the case. And I'm often coming in, editing our brief just a few days before we're going to file and asking the questions that are much bigger picture, not trying to rewrite a paragraph or get into the weeds on some minute point, but instead taking a step back and asking a big picture question about our argument or about the nature of a claim we're making in the case to make sure I understand it. And I feel like it's a different role to try to add value in that way. But one of the things I can bring to bear as part of that is that I am seeing, the range of cases in which we're making arguments. And so as a result, I can sometimes see the way that different cases or issues relate to each other and connect up for purposes of trying to make sure, again, that we're being consistent, that arguments we're making over here in this one context aren't undermining our interests, over here in this other context. And it's another really wonderful role to play and to have that kind of breadth across the office of what we're doing.
So one of the reactions I had to becoming a law professor and reading a lot of law school exams is that I concluded that knowing what I learned from that process, I felt like I could go back and be a way better writer of law school exams as a person who's now read a lot of law school exams. And had to grade law school exams. And you mentioned that shift from being a line attorney to being, principally an editor and reviewer in your office. I guess I'd say, what lessons have you learned from your sort of new job that you would have told the person who had your old job as a person who was a primary drafter for a busy person who's reviewing a lot of things? What are the things you'd say that your current experience has taught you that you wish you would have known when you had your previous jobs?
That's a great question. One thing that comes immediately to mind is that there's often not just one right way to do something. I think I, in this role, am exposed to a wide variety of different strategic choices about how to write a brief, how to organize it. I feel like I am learning on the job every day by watching my amazing colleagues, approach cases and write briefs. And it's been really interesting to me as just someone who loves the law and loves the art of writing to see the various ways in which the attorneys in my office take on these cases and brief these issues. And so I think to the extent as a younger attorney, a line attorney, kind of where I was sweating, thinking, am I getting this one right? I think one thing I would tell myself back then is there's not necessarily one right way to do it. There are going to be a lot of different ways to be an effective advocate. And there's no kind of universal formula for how to write a good brief. You really have to be true to yourself and to your own voice. So that's one thing I would think through. And then, the other thing in this role that comes up for me sometimes is that trying to distill a case to its essence is, I think, really important. So I find the most effective briefs to be those that don't take too much for granted or too much knowledge for granted, that make it easy to follow along. And, in my role, it's often because I'm going to have not that much time to spend on a case. I am not going to be in the weeds of this particular provision of the bankruptcy code or ERISA or whatever statutes at issue in the case. And the briefs that are really effective are those that find a way to explain the case to someone who's new to it, in a way that's really comprehensible. And I certainly appreciate that in this role when I'm the one picking up the pen and having to jump in onto the case. But I think it also mimics to some degree what the justices themselves are likely experiencing because, they have a huge docket as well and a tremendous caseload. And so making their jobs easier by virtue of making the case easy to follow and understand, I think is a way to make the brief all the more effective.
And sort of then a related question that goes back to your work in reviewing these recommendations about whether to appeal. So you mentioned, back in the day, and that's when I worked there was like a physical packet that could be several inches high, and now you get this mass of memos from people. What do you find most helpful about those memos, and what would you what would you just like to, it occurs to me that a lot of people who might be listening to this webinar might have a similar relationship in one job or another they have, where they're essentially writing memos to someone who's their supervisor. And what do you find most helpful in those massive memos that you have to review day in and day out?
So it's interesting because a lot of it is the same, the clarity, being able to just for someone who's new to a particular subject matter, recognize that they're not going to necessarily know all the acronyms or understand, the in the weeds details about how a complex statutory scheme works. That's kind of key. But one of the things that's interesting about this recommendation process is that the further along you go in who's writing the recommendation, the shorter the memo gets. So, we might get a memo from the tax division that's 40 pages long, and that is really going into substantial detail about every single issue in the case. And that makes sense because they're on the front lines teeing up those issues. And then it's going to come to an assistant in my office who's going to write a 10-page memo, and then to the deputy who might write a 2-page memo. And I'm looking at all of those memos, but I'm getting different things out of each of them. And I almost always start with the shortest memo, the deputy memo, just to give me the 30,000-foot view of here's the issue in the case, here's the basic decision point you're facing, and here's my way of thinking about it or what I recommend to you. And then I'll go down the line, accordingly. But I guess for those who are listening, who are thinking about how to write an effective memo, the number one thing I would say is try to write it clearly, try to be clear, and read it with an eye towards the view of someone who's going to know 10% of what you know about this issue or this case, and try to really interrogate what you put on the paper and whether it's going to be comprehensible to that person.
Well, great. I think we have time for one last question. I'm going to take one from our audience, which is, you mentioned that your office participates in about 80% of the Supreme Court's cases. You obviously don't personally argue every single one of those cases. So talk a little bit about the process of deciding who's going to argue which case, and in particular, which ones you're going to do personally.
Sure. So by longstanding tradition, the SG personally argues usually once per sitting. So, that averages out to about 7 arguments a term because this year I've been going in every month and arguing a case on behalf of the federal government. And the calculus for deciding which cases the SG should argue really comes down to what case is most important to the United States in that particular sitting. Sometimes it's obvious, there's a kind of major case that's going to be front page news. Maybe it involves a huge and important policy for the administration, or just a fundamental and profound legal issue. And that's obviously going to be the case for the SG. This past month, just a couple of weeks ago, I argued the cases about whether the court should overrule the Chevron deference doctrine. And that's an issue of profound importance to the federal government that affects virtually every agency within the federal government. So those were the clear SG cases for that sitting. There are other sittings where there are a bunch of big cases and it's a harder decision point. And there's not kind of a mathematical formula I apply, but I take counsel from others in trying to ascertain which case is actually going to have the biggest effect or where I think I can make the most difference. And the good news is I have this amazing team and these great attorneys. And if I'm not going to personally argue it, it'll usually go to one of my deputies or to one of the assistants in the office. And so I always know that the cases are in good hands, even when I can't do them.
Well, great. I want to thank you so very much for taking the time to be with us. I learned a lot, and I'm sure a bunch of our panelists did as well. So I think with that, though, we are out of time, and I will turn the floor back over to Nikki. Thanks very much.
Thank you so much, Judge Heitens and Solicitor General Prelogger, for that incredibly interesting and revealing discussion about the Solicitor General's office. I would now like to welcome the members of our second panel to join me on screen. Our second panel, Effective Advocacy Before the Fourth Circuit, Perspectives from the Bench, will be moderated by Michelle Callan. Ms. Callan is an experienced appellate lawyer who has had a fascinating and diverse career working in both the public and private sectors and appearing before both state and federal courts. She is currently a partner at the law firm of Jenner & Block, where she is a member of that firm's Supreme Court and appellate practice group. Prior to that, she served as the 7th Solicitor General of Virginia, working on a variety of matters, including Virginia's effort to have the Equal Rights Amendment certified as the 28th Amendment to the U.S. Constitution. She also previously served as Special Litigation Counsel to the United States House Select Committee to investigate the January 6th attack on the U.S. Capitol. Not surprisingly, given all these accomplishments, she has been recognized as a rising star by both the American Bar Association and the National Law Journal, and has also been honored for her extensive pro bono work. And I can only imagine that she is looking forward to turning the tables a bit and asking the questions to a panel of 3 judges. Ms. Callan, thank you so much for being with us today, and I turn the floor over to you.
Thank you so much, Nikki. Good morning, and I have the pleasure this morning of facilitating a discussion with Chief Judge Diaz, Judge Rushing, and Judge Benjamin. So we'll start with some introductions. The Honorable Albert Diaz is Chief Judge of the Fourth Circuit. Before his nomination to the Fourth Circuit in 2009, Judge Diaz sat on the North Carolina Superior Court bench, including service on the North Carolina Business Court. Before joining the bench, Judge Diaz served as a prosecutor, defense counsel, and appellate government counsel in the Marines. After he left active duty in 1995 for private practice, Judge Diaz remained in the Marine Reserves and served as appellate defense counsel, military trial judge, and appellate military judge. He retired from the Marines in 2006 at the rank of lieutenant colonel. Judge Diaz has been active in the Mecklenburg Bar and in the ABA. He holds a Bachelor's of Science in Economics from the University of Pennsylvania, a JD from NYU School of Law, and a Master's of Science in Business Administration from Boston University. Next, we have the Honorable Allison Jones Rushing. She joined the Fourth Circuit in 2019. Before joining the bench, Judge Rushing practiced law at the law firm of Williams and Connolly, where her appellate advocacy skills were recognized by national publications, including Legal 500, Super Lawyers, and the National Law Journal. Before entering private practice, Judge Rushing clerked for judges of the United States Court of Appeals for the 10th Circuit, the United States Court of Appeals for the DC Circuit, and the United States Supreme Court. She holds a Bachelor's of Arts from Wake Forest University and a JD from Duke University Law School. And finally, we have the Honorable DeAndrea Gist Benjamin. She was confirmed to the court in February of last year. She is the second African-American woman and the first person of color from South Carolina to serve on the Fourth Circuit. Judge Benjamin clerked for Judge Casey Manning, resident judge for the Fifth Judicial Circuit in Columbia, South Carolina. Following her clerkship, she served as an assistant solicitor in the Fifth Circuit Solicitor's Office and as an assistant attorney general and lead Violence Against Women Act prosecutor for the South Carolina Office of the Attorney General. After her public service, Judge Benjamin served on the South Carolina Board of Juvenile Parole and was a municipal court judge for the city of Columbia. In 2011, Judge Benjamin was elected by the South Carolina General Assembly as a resident judge for the Fifth Judicial Circuit. Judge Benjamin is active in the legal community, including the American Bar Association and the South Carolina Bar. She holds a Bachelor of Arts from Winthrop University and a JD from the University of South Carolina School of Law. So I'd like to start out with the big picture. What are the characteristics or attributes of a successful appellate advocate? What do great appellate advocates have in common? And let's start with Judge Diaz.
Well, thank you, Michelle. I think probably the most concise, direct answer I could give to that question would be CEG, Solicitor General Elizabeth Prelogger. If you could clone the attributes of a successful advocate, I imagine many of the attributes that she exhibits would be the ones that we would try to emulate. But obviously not everyone can rise to those heights, but I think there are things that certainly are common and certainly we see across the board with respect to effective advocacy. First and foremost, there just is no substitute for preparation. Uniformly, the most effective advocates in our court are the ones who were well prepared. I think it was Thomas Edison who said that genius is 1% inspiration and 99% perspiration. There's no substitute for being prepared. Because if you're prepared, then you generally exhibit the level of confidence and knowledge of the case that will help you to engage with the judges who are primed to ask certain difficult questions. The other thing that I would go back to, I think this is a point that the general made, is that we're all very, very busy judges. So we're looking for the most efficient, effective way for an advocate to present his or her case to us in a way that's comprehensible, and sometimes in an area of law that we know nothing about. So an effective advocate is really good at that. It goes without saying that being an honest broker, someone who the court can depend on, not just for information that is helpful to you, but information that might hurt, and an ability to explain why it doesn't really matter in the end, that you should win in any event. But an advocate who is whose integrity is unimpeachable is certainly critically important. And we can tell. We know the advocates who we can count on when they come into the courtroom, and to a much smaller degree, we know those who we have to, think twice about before deciding whether or not what they're selling is what we should be buying. I would, I would leave it there and then turn it over to my colleagues for additional comments. But that, in broad strokes, is what I generally see when I see an effective advocate.
Judge Rushing, anything to add on what makes an effective advocate?
Thanks, Ms. Callan. I, of course, agree completely with what the chief has said. I think being the expert in your own case is essential. And that comes across in the briefs and at argument, knowing the law and the facts better than anyone else, so that we can rely on what the advocate's saying. And I'll just add one more quality of an especially effective advocate, in addition to what the chief mentioned, is I think an effective advocate addresses their adversary's argument head on. Too frequently we encounter briefs that are, ships passing in the night, and so lost opportunity for an advocate to take the other side's best argument and explain why they still shouldn't prevail, explain what's wrong with it or why it doesn't matter, or whatever, but give the court an explanation. Otherwise you leave us thinking that you have nothing to say. So I would add that.
Great. Judge Benjamin, anything to add?
I would agree, knowing your case, being prepared, as Judge Rushing said, being the expert in your case. The court should not know more about your case than you do. And so just being knowledgeable, knowing the record, knowing the law, and being able to address the questions and the arguments before the court.
Great. So we'll kind of start then by going in order of what happens over the course of a case. So we can start with the briefs. Approximately 80% of non-pro se cases in the Fourth Circuit are decided on the briefs. And whether or not a case is argued, the briefs are extremely important. So on that topic of the briefs, Judge Rushing, what are you looking for when you pick up a party's brief? What draws your attention? What takes away from your attention?
When I first pick up a brief, I'm looking for, what am I being asked to decide? So I can consult the table of contents, the statement of issues, to find out, what am I being asked to decide here? I'll note as a side point that I shouldn't be asked to decide more than 3 or 4 things. If you have 9 issues, if you're the appellant and you raise 9 or 10 issues, that suggests that you lack discernment in figuring out which ones actually have merit. But in addition, the question that the judge is being asked to decide is more specific than, did the district court err in granting summary judgment or something like this? It's the pivotal point. What is the specific question of law or fact that this case turns on, or that this issue turns on? That's what I need to know. That's the question I'm being asked to decide to resolve this case. So I'd say what detracts is sometimes that can be hidden under a lot of preliminaries. And you can get to the end of the facts section and not really know, well, what did they think went wrong here? Or what am I being asked to decide? So I think when I open a brief, I'm looking to find early on at some point, the advocate's point of contention. This is the issue. This is how you should resolve it. Then, of course, you can back up, give a longer explanation, background, etc. But keeping with our theme today that judges are busy and you need to make it easy for us, the the question we're being asked to decide and why you win should be unmissable.
And do you find that the summary of the argument is a good place to do that, an introduction, or any advice on a particular place in the brief where you think that that's best highlighted?
Yeah, I'm not picky about where that is. I look at the table of contents, statement of issues, intro. I know some of my colleagues really like the summary of argument for that. So any of those places are opportunities to do this, but it should be done early. I think I wouldn't wait till your summary of argument to make your point. And then, you can, again, zoom out and explain more, but putting it prominently somewhere, which, as you're pointing out, can be done by structure, right? Even if it's not the first thing you say, so you have to tell us why you have jurisdiction, why we have jurisdiction, right? But even if you don't say it first, careful structure, putting it at the beginning of a new section, et cetera, can highlight it.
Thank you. Judge Benjamin, kind of on the note of the contents of the brief and the structure of the brief, what do you consider to be the most important section of a brief?
The summary of the arguments in the analysis. Why do you want me? Why do you want me, or how can you convince me to agree with you? Explain why binding precedent supports your position.
And on that note, so binding precedent, that's the law. What about the facts section? What do you think makes an important facts section? What's helpful? What do you find not helpful?
Give us the facts that we need. You can give a roadmap of the facts that the court needs, not all of the facts. If you're before the court on a dismissal of a 12B6, then we should be looking at the complaint. You should not address it as if it is a summary judgment, a granting of a summary judgment. So know exactly what it is that you're before the court and address those facts, not run on facts on and on and on.
And Judge Diaz, so I've heard through the grapevine that there are some judges who complain that briefs are too long. What do you think about that? Do you agree?
Well, I'm still waiting to hear from the first judge who complains that briefs are too short. So I think I'd obviously agree with that as a general proposition. And it's a balancing act. Obviously, advocates want to be able to get their point across, and there's a reason why the briefs are set up in a way that provide for what I think are generally pretty ample word limits and page limits. But there's nothing that says that an advocate has to use every single word or every single page to get his or her point across. And it gets back to the point about judges being busy, but we're all busy. Lawyers are busy too. But I think in order to make the brief count, an advocate has to make a conscious decision, first of all, to begin the work early enough so that he or she can take a step back from it and edit it ruthlessly throughout the whole process before filing it, because it's pretty easy to write a stream of consciousness about any particular issue. It doesn't take much effort to do that, but it does take a lot of hard work to be able to get to the nub of a matter in a way that is comprehensive yet concise. That's hard to do. And so the only way to do that is to give yourself sufficient time to be able to engage with a brief and perhaps have others engage with it, so that by the time it gets to the court, it is the most efficient, comprehensive, yet concise piece of advocacy that you can submit on behalf of your client. And if you go through those processes, then you're going to generally have a bunch of happy judges. If you don't, then we're going to be a little bit grumpy.
And in addition to the process, do you have any kind of concrete tips of methods or ways that advocates can look to trim down a brief a bit?
Well, I think Judge Rushing made a good point, particularly as the appellant. It can't possibly be the case, although we see it, that you have 8 or 9 winners that are all zingers. That just can't be right as a matter of practice in a trial. It's an imperfect vehicle for getting at the truth. It's the best vehicle we have, but it's there's a reason why we have harmless error analysis. So part of it is just as an appellate in particular, being able to figure out what matters. And once you get to those 2 or 3 issues, as Judge Rushing said, that's half the battle, because by definition, the brief is not going to be anywhere near as long as if you've taken the time to be able to engage in a way that narrows the issues to those that really matter. As the appellee, I think you're in a better position because you get to respond to the arguments that are presented. And so by definition, your brief should be more concise and narrow. But that doesn't mean that you get a pass on the editing process as the appellee. You also have to make sure you use your time wisely to address succinctly and directly the arguments that are being made. I think it all goes back to being able to take the time to edit a brief. And one of the things that I found valuable in not just in briefs, but in opinions, if you take a few days away from something, it's remarkable when you get back to it, how much more efficient you are as an editor. So I would encourage people to do that. But again, in order to do that, you have to give yourself the time. If you wait till the last minute to prepare a brief, you're just not going to have the time sufficient to do that. But I've seen that work remarkably well in terms of being able to edit and be much more concise in my writing.
So this is a question that came in from the audience about the structure of a brief, and it's to what degree, it doesn't matter if at all, that the structure of the brief, that the responsive brief of an appellee brief, for example, or even a reply brief, the answering brief, that it is structured along the same lines as the brief that it's responding to. Do you find it helpful for it to generally mirror the same structure? Or if the logic of the appellee's argument, for example, differs a little bit from the appellant's, that brief departs from the structure of the brief it's responding to? And I'll let anyone jump into this question.
I'll jump in. I don't think it's essential that they mirror each other. The appellee sometimes can make a point by taking a different order of arguments because they think the appellant buried something important at the very end. And so sometimes it really matters. I do think what matters for us is that the parties are clear about where they're addressing each argument. As the appellee, you want to respond to every argument the appellant raises. And as long as you flag that in the headings, and I can find that in the table of contents, then I can match up the arguments and compare them. So I don't think you have to do that. And I think strategically, sometimes it's wise not to.
That definitely makes sense. And I guess turning kind of, this is a follow-up question from the same questioner in the audience, but it kind of turns us to the next question that we had on our list to discuss. Are there brief formats or layouts that you all prefer or that you all dislike? And in addition to that, any additional kind of pet peeves that you have when it comes to briefs? So maybe I can start with Judge Benjamin on this.
So mine would be too many footnotes. There's a footnote on every page, and it's and the footnote begins to be an argument. Put it in the body of the brief. Sometimes I feel like it's distracting when you have too many footnotes in the brief.
Any other pet peeves from the panel?
So as I've gotten older, I think it's become much more critical to me that the brief actually use a font that can be read easily. I don't know that there are any particular restrictions on the fonts that we allow, but there are some that are just awfully distracting, like Courier New, for example. As I've gotten older, it's just really hard to focus on a brief that uses that kind of a font. We use Times Roman in our opinions, and Century School Book is another font, and I'm beginning to describe myself, I think, as a nerd now, falling into the rabbit hole of fonts. But they do. I mean, like everything else, anything that distracts from your argument is going to be a problem. But Judge Benjamin's point is a good one about footnotes, block quotes. I mean, I saw recently a brief that was essentially just the greatest hits of block quotes from the Supreme Court of the last 15 years. That's not very effective. I don't think they can be used sparingly, but I would try to avoid that. And one point that I'll make before, not directly related to your point, and this is going to sound contradictory, but you mentioned reply briefs. Having said that, I've never met a judge who thinks that briefs are too short. I frankly find it surprising that appellants often waive the right to file a reply brief. I just, for me, it signals something, not necessarily a good thing if you don't have anything to say in response to the appellee's argument. So unless there's a really good reason, and frankly, I can't often think of one, an appellant should rarely, if ever, waive the right to file a reply. Now, having said that, you shouldn't file a reply just for the sake of, if you've got nothing good to say, but hopefully the reply will achieve its purpose. But it often leaves me wondering when an appellant doesn't file a reply brief.
Great. So Judge Rushing, we now in the age of electronic submission, and with the prevalence of folks kind of using computers both to draft brief, but perhaps read briefs, do you have a preference between electronic or paper briefs?
I do. I strongly prefer paper. I think that's probably the minority view. I think if you polled my colleagues, the majority of them are reading on some sort of screen, their iPad or their computer. I like paper because I like to, I usually read the briefs seriatim. So if there are 3 issues, I read each party's brief on that issue usually. So I like to have everything open at once, and it's easy on the eyes to look at a piece of paper rather than a screen. So I think we do still require parties to file paper briefs, and I'm very appreciative. We also have paper joint appendices, which I use. I like to, tab the relevant portions and have them in easy access. And I find being able to use the paper appendix very useful, especially if I'm drafting an opinion in the case. So like I said, I think I'm in the minority there, but it's useful for me to have the paper.
So for those advocates in the Zoom room here who might be a little disgruntled sometime about having to submit those paper copies, they're going to good use, at least definitely in Judge Rushing's chambers.
There's at least maybe 2 or 3 of us who do actually read them. So thank you.
Judge Benjamin, what are some ways that an advocate can build some credibility in their brief?
And just to join Judge Rushing, I like paper briefs also. I know that seems a little maybe that's I don't know. It's just easier for me to I'd rather read a book than read it online. And same thing, I make notes in the brief, I flag it, so I enjoy having, I would prefer having a paper brief before me. And then your next question, I'm sorry, was?
How does a brief build some credibility?
Well, if it's reliable, if it's concise, if the arguments are handled, if the arguments are handled appropriately, but if there's something in there and I go back and look at the JA and it's not supported, then of course it is a little concerning to the court.
And on that note, building credibility, so do you find it helpful if a brief is discussing a particular case for that brief to use extensive, maybe not block quotes, but quote the case itself as opposed to paraphrasing the case? Is that a way of adding credibility, or do you find that either way, as long as the reference to the case is generally accurate, then it doesn't really have much of an impact on credibility? Or do you find that kind of use of quotation marks is a good indicator that the case is being used in a credible manner?
And in paraphrasing, yes, as long as it's credible, I don't have a problem with quotations or paraphrasing.
Great.
Can I chime in
sure.
on that?
Mm-hmm.
I completely agree with Judge Benjamin that credibility is key, and being accurate is the way to do that. And when it comes to quotations, I think I do like seeing, the legal standard or the key holding of the case quoted, because then I know I can trust, what the advocate's saying about it. But to Judge Diaz's point about block quotes, sometimes quotes are put in to kind of substitute for an argument. And the quote is about the case you're quoting. It's not about your case. And so a quote can never substitute for a persuasive argument about why that leads to victory in your particular case. So I think that's how I would distinguish between a useful and a distracting use of quotes.
That's a very helpful, concrete tip.
Michelle, can I chime in about the paper versus plastic or paper versus electronic? So I guess I'm the odd person out. For a long time, I would read briefs as Judge Rushing and Judge Benjamin still do, but more and more I've gotten away from paper, and there's no one way to do it. Everybody has to do it the way they feel comfortable. For me, because I've been doing a little bit more traveling these days, it's just awfully convenient to have the briefs in an iPad, for example, and be able to look at them that way. And now that I've gotten a little bit more able to use the iPad effectively, I find that in terms of making notes and the like, it's easy to do that on the side of an electronic brief as well. So it can be a strain on the eyes. Obviously, there's pros and cons to everything, but I think the technology works well, and I think most judges are going that way.
On the topic of technology, anyone can chime in here, what are folks' thoughts on artificial intelligence in brief writing?
Well, I guess I'll start. Obviously, we've seen the lines of lawyers getting into trouble using artificial intelligence to either draft sections or perhaps entire portions of a brief, or the use of phantom sites that don't really exist in briefs. So it's technology, like anything else, like we're talking about electronic briefs. It's a great tool if used correctly and appropriately, but it's no substitute, I think, for the lawyer's individual judgment and talents as a lawyer. I think that's sort of the lesson that I would impart to the bar. I saw a recent piece or a submission by the New Jersey Supreme Court on this topic, directed both at the bar and at the judges. And the court basically said, look, artificial intelligence is not going to go away. It's here. It's a part of what our lives, and certainly lawyers are not necessarily barred from using it. But in the end, the rules of professional conduct apply to everything that you do as a lawyer, including the use of artificial intelligence. And so those same regulations and restrictions need to be taken into account whenever a lawyer decides to use any kind of tool, whatever it may be, in their advocacy work. And I think that's pretty good broad advice. And then to the judges, the Supreme Court sort of gently admonish their judges, to be careful that artificial intelligence doesn't substitute for the independent decision-making that is the hallmark of every court and what we do. And so I think that's pretty good advice. We use AI every day, whether we realize it or not. Every time we use LexisNexis or Westlaw, it's a bit of artificial intelligence. I know a lot of judges who use editing and other software for opinions and the like. So it's here to stay. It's not going to go away, but I think we just have to take it and use it like any other tool without, abdicating our role as lawyers and judges.
So I have two questions here on the block quotes and pet peeves issues from our audience. One of them on the block quotes issue is, what about block quotes from the record? Do you find those more helpful than block quotes from authority?
I think it's just going to depend on whether your case warrants it, right? If your case is about a paragraph from a contract, then putting that paragraph in a block quote in the brief might be important. So if it serves your case, I think that's obviously a little bit different.
And then on the kind of further pet peeves piece of things, one of my personal pet peeves is the cleaned up parenthetical. I'm not a huge fan of it, but I know folks agree or disagree, and there are a lot of strong thoughts there. Do any of you have a sense as to kind of strong feelings on the cleaned up parenthetical, or you can go either way?
Well, I use that for my opinion. So obviously I don't oppose it. So, but like anything else, the point is trying to make sure you get the information that's necessary to the judge in order to be able to decide your case. And if using cleaned up in a particular circumstance doesn't detract from that, and oftentimes it doesn't, because it helps the reader to be able to navigate what can otherwise be a fairly dense number of citations and parentheticals. So like anything else, it's a tool to use if it proves helpful to the ultimate objective.
Great. So one of the features that folks who practice before the Fourth Circuit know is that the Fourth Circuit is the Fourth Circuit, at least advocates, we learn the identity of our panels that morning. But we know that's not the case for the panel, for the judges themselves. So Chief Judge Diaz, when do you know the cases that you're going to have in a particular sitting and your co-panelists for particular sessions?
So we're trying our goal is to try to get the calendars out at least 6 to 8 weeks before the argument session to give everybody an opportunity to be able to sufficiently prepare. So that's when you first find out who the panelists are, generally about 6 to 8 weeks before the calendar week, the session week.
And to everyone on the panel, when do you start reviewing the briefs in preparation for sittings? And does it depend on what you have on your plate at the time?
Yeah, at least for me, it just kind of depends on what else is going on. At a minimum, I'm dedicating, the week before argument to the cases, but it usually requires more than just that. So I kind of fit them in, in the weeks ahead of that as well.
And how do you all use your clerks leading up to oral argument?
So each of the cases that I'm involved in, my clerks prepare a bench memorandum for the case. So that's actually the first thing that I'm waiting to get before I turn to a case is the bench memo, because that's typically the first thing that I'll read. And so as I get those in is when I start to turn to a particular case and just go through them as they come in.
I usually look at the lower court opinion. My clerks each will be assigned a case, well, usually about 4 cases. And but I look at the lower court opinion, and then I usually wait on my bench memo from the clerks, or sometimes I'll go straight into the briefs myself, and then discuss their thoughts on it once I receive the memo from them.
I'm going to jump in here with an audience question before we move on now to oral argument. And this member of the audience asks, what portion of the docket is made up of pro se cases? And then does the court find opposition briefs helpful in appeals filed by pro se plaintiffs that are set on an informal briefing track?
Our clerk of court is here somewhere, so she would have the precise numbers, but it's a significant number of cases that are part of our docket. Much more, one of the things that surprised me when I came on this court was just how many cases we get that involve pro se litigants, and a good number of them are prisoner cases, not surprisingly. And so they take up a pretty good amount of our time. I just got the answer. Melissa Wood, OSC, our trustee, director of Office of Staff Counsel, says over 50% of our cases are pro se cases of one form or another. And what was the second part of your question?
whether it's helpful to have an opposition brief when the case is set on an informal briefing schedule.
Well, and the panel obviously can call for a response, and sometimes it does. It just depends on the issue, and and oftentimes, not often, but sometimes we'll look at an informal brief and decide, there's something here that warrants further consideration, and we may appoint counsel to the matter. In which case, if we do that, then certainly we'll call for a response brief.
Right. Well, let's move on now to oral argument. For those who have an oral argument opportunity, Judge Rushing, how important is oral argument, and what is the impact of oral argument on your decision-making process?
I think oral argument does matter. It matters, I think, significantly at our court, at the Court of Appeals. We usually, in my experience, come into argument with a tentative view on a case, but hearing from the advocates is important. And I think maybe even more so, for us, it's the first time usually that we hear from the other judges on the panel about the case. So I find it very helpful to hear my colleagues' questions of an advocate and the responses. So I may have questions of my own, concerns that I want cleared up, but being able to hear from my colleagues and get their perspectives is also very useful. And so sometimes I think as an advocate, you don't realize that we're there to hear from you, and we're also there to hear from each other. So the discourse among the judges is helpful and important to the decision-making. And I think argument, whether it changes someone's vote, which it certainly can, it can change the way that you view the case. It always affects the way the opinion is written, I think, because we have distilled and refined the issues that really matter to the panelists. So take heart. I think argument really does make a difference when you get to do it.
And I know that some circuits share bench memos before, and the judges talk about the case before. Judge Rushing, you mentioned that one of the valuable parts of oral argument is hearing what your colleagues are thinking. In the Fourth Circuit, is that typically the first insight that judges have of each other's perspectives on a case?
Yes, in my experience, argument is usually the first time you're hearing from your colleagues about the case. We don't have a formal practice of sharing memos, or I know some circuits share, their clerks, one clerk for each judge, one clerk for a judge writes a memo and it goes to the whole panel. That's not typically how we do things. And so occasionally judges will talk beforehand to share concerns or raise an issue that they would like to hear addressed at argument. But more often than not, it's the first time that we're hearing from each other about the case, and that's very valuable.
So this one is an audience question, but the question is, has your vote ever changed because of an oral argument? And I know that there are some folks who've suggested that oral argument is not particularly important, but can you think of a time in which oral argument was important in the way that your vote changed after oral argument?
Oh, sure. I'll let my colleagues talk too about this, but as I said, sometimes you come in with a very strong view about the case based on the briefs, but other times, it's tentative and how argument goes and what counsel has to say. And again, points that your colleagues raise all, can push you over the line one way or the other. So I think the combination of argument and then the conference we have afterwards, I've definitely seen it, change minds and change my own mind.
Go ahead, Judge Benjamin. Sorry.
Yes, I have. I try to go in with an open mind, but sometimes you have these preconceived, ideas as to where you're headed, or what you think the case or what the results should be in the case. And it's always good to, as Judge Rushing said, to hear what the concerns your co-panelists have and and the oral and the arguments themselves. So I have changed my mind about a case after arguments. So they are helpful.
I don't have much to add. I agree with the points that Judge Rushing and Judge Benjamin made. In my time on the court, I've been surprised how much more often than I had expected when I first came on the bench, my mind has been changed by an argument and by the comments and questions of my colleagues. So I do think that the process is quite valuable.
So on the process and kind of the image of what happens, I want to paint a bit of a picture of what it's like walking through the doors at oral argument. So an advocate shows up, they learn the identity of the panel in the Fourth Circuit that morning, and then they learn the location of the argument. So I have a bit of a trivia question for the group. And that question is, when is a pattern a color? And the answer to that question is when arguing before the Fourth Circuit. So the reason for that is because the rooms where the oral arguments take place are described based off the color of the carpet in the room. So green or tan, with one exception, and that's tweed. So in the Fourth Circuit, tweed is apparently a color. I'd be very curious to hear how that came about and whose call that was. But in any event, that's the kind of one of the fun things about the Fourth Circuit. You could be arguing in a room, the tan room or the tweed room. But carpets aside, when an advocate arrives in the courtroom, Chief Judge Diaz, what do they see? What's the layout of the room? And in particular, because one of the things that's a little bit striking about the layout of the Fourth Circuit, where's the podium?
Sure. Let me back up to something you said about when an advocate finds out who the panel is going to be. We are, I think, one of two circuits that still adheres to that requirement that we don't disclose the names of the panel members until the date of the argument. Every once in a while, I'll get some pushback from lawyers here in North Carolina about that and why it should be that way and why we might suggest changing it. I don't expect that we will, although, never say never. I think the reason for that, one of the reasons, as I understand it, and there's probably some truth to this, is that we prefer that the arguments be directed to the merits and not to a particular judge and or his or her prior history in the case. And we think that the argument is better situated that way. So that's the reason. It does sometimes lead to interesting stories. And I'm not going to go into this full story, but way back when I was on the court as the first or second year on the court, Justice Sandra Day O'Connor came to sit with the panel, and she ended up on a panel that Judge Wynn and I were on, and we had a young lawyer who showed up, and no doubt was surprised to see that Justice O'Connor was on the panel, and he found out that day and was very, very starstruck when he came up to the podium and could barely get a word out until he finally calmed down and the argument ensued. So that can happen occasionally. But so advocate walks in because of COVID restrictions. We've moved the podiums now to the council table. By and large, at some point we may move back to the center of the courtroom, and so that's where counsel will typically appear. We often get the question of where lawyers should sit. It doesn't matter. It's every man or woman for himself or herself. Whoever gets to the tables first is where you will sit. And most of the courtrooms, including that Tweed courtroom that you talked about, are pretty intimate courtrooms. So you're pretty close up to the judges. The en banc courtroom perhaps being the exception, a larger courtroom. So that's generally what you'll see. Obviously the judges on the panel, 3 law clerks over on the side, and the court personnel.
Now, one interesting thing about the en banc courtroom too is for en banc arguments, the way that the kind of U is shaped, the newer judges sit a little bit behind the advocate, and so if for folks here on the Zoom screen who have an opportunity to argue an en banc case, it might be helpful to know some of the more junior judges' voices a little bit, because they might be asking a question and they might be a little bit behind you. And occasionally you'd hear a judge saying, no, over here. And you kind of have to turn around. And so just knowing that the U shape is such that as the advocate, when you're standing at the podium, if the podium is in the middle of the where it has been in the past, sometimes judges might be behind you. So that was a helpful tip that I received about the en banc layout in the Fourth Circuit. Well, Judge Rushing, question for you. I'm sure you've seen a whole array of advocates coming to the podium, bringing things to the podium. I guess now if the podium's at counsel's table, you don't really physically bring anything, but some folks will still kind of raise their materials and bring it onto the podium. Have you seen an advocate bring anything particularly interesting to the podium? And do you have any advice about how much should be brought to a podium?
I'll say when I was an advocate, I would bring a binder. I had one, small, like 1-inch binder, and it had everything that I thought I would need, all the important record sites, the most important case law, and sort of reminders of the main points I wanted to get across. That saves you from having to bring up all 10 volumes of the joint appendix because you want to be prepared in case the judges have a question, where in the record was that? So you do want to be prepared, but you can often anticipate those questions and not have to haul everything up with you. But I don't really, it doesn't bother me if counsel does bring, too much or not enough up to the podium, as long as they're able to answer the questions, talk about the case. You do sometimes now see, people who are savvy like Judge Diaz bringing up iPads instead of written notes. And, that might be an effective way to have the whole record there at your fingertips. Just make sure that everything is at your fingertips and you don't have to scroll and make us all wait while you try to find it. In terms of the most interesting thing, I don't think there's been anything particularly entertaining that I've seen at the podium. I will say just recently, the most interesting thing someone brought up was nothing. Not for the main argument, not for the opening argument, it was an appellant, but on reply. And this is in a courtroom where the podium is in the center off of counsel table. And after hearing from the appellee, the appellant jumped up and, sprang to the podium without anything in their hands. And they were eager to tell us, the main 3 points of why we should still rule in their favor. And I thought that was striking and effective, but I don't know that you win any points by coming to the podium with nothing. It's impressive, but it's, if it doesn't help you persuade, then, bring what you need.
And we have 2 questions from the audience here, actually twice this question. What about demonstratives at oral argument?
I don't think I've ever seen it. Oh, maybe I have actually. I take that back. In an intellectual property case, we had the thing itself there, which was useful. We're not a jury, so often an illustration is going to be off topic for what you're trying to convince the panel of 3 appellate judges to decide. But, I'll hedge it with, that was a very interesting case where we got to see the product itself. So my colleagues may have other insights on that.
I've not seen any demonstratives in my short time on the court.
My general thought about that is you've got 20 minutes, so it's not a lot of time to deal with demonstratives and other things and get your point across. So I've seen a couple of requests come across panels that I've been on that have been denied. There was one case, as I recall, where the lawyer wanted to bring in the bike that was defective that caused a personal injury, which I think seemed a little bit overkill. So like anything else, maybe in an IP case, assuming the thing isn't too unwieldy, it might not be a bad idea. But again, anything that detracts from the little time that you have, you might be better off just doing without.
But Chief Judge Diaz, as you noted, it has to be requested of the court. Folks can't
That's
just
true.
bring
Right.
in demonstratives.
Now, you can't ride the bike into the courtroom without first asking.
I think it might be hard to fit in the small Fourth Circuit elevators as well. I don't even know if a bike might be hard to fit it in there. So Chief Judge Diaz, when an advocate gets up to speak, what should they say first? And I want to cross-reference what Judge Heitens and General Prelogger discussed earlier. They talked about the Supreme Court now allowing advocates to begin their argument uninterrupted. What about the Fourth Circuit? Do you find that now there's kind of a respected time for advocates to speak before folks jump in with questions?
So we have no formal policy about that, although I think most of my colleagues are pretty good about letting an advocate get his or her bearings before, boring into them about questions. You asked about what's the first thing that one should say. A little formality never hurts. May it please the court. My name is so and so, and then I think it's really effective when the appellate gets up and says the issue, and hopefully it's one issue, not multiple issues. In this case, is, and then succinctly explains what the issue is and dives into the argument. And generally, I think you'll find that you'll have sufficient time to do that before the questions come flying.
And when the questions do come, Judge Benjamin, do you have preferences, or do you know of other judicial preferences in addressing the judges in the Fourth Circuit? Use judge's name, say your honor, any pet peeves with use of the phrase, the term ma'am or sir?
I think it's preferable that you say your honor, or you call it Judge Benjamin, Judge Rushing, Chief Judge Diaz. That is preferred. I know some judges don't like ma'am or sir, but I am from South Carolina, so where you're trained at a very young age to say ma'am and sir, and so it doesn't bother me. I came from the state court, and I've been called a lot of other things. So ma'am and sir does not bother me, but I think what is preferred is your honor, or to address the judge by their name.
But if folks are addressing a judge by their name, no to correct it, to pronounce it correctly.
Yes.
So this is for the group. Can you recall a particular oral advocate, perhaps without identifying them, that stood out as being particularly effective? And what was it about their argument that you found very effective? Maybe Judge Benjamin, we can start with you.
Yeah, I think being able to, sometimes you'll have a hot bench, and being able to remain calm and answer their questions. Whatever you do, don't interrupt the court. That is, I've seen that happen. But remaining calm, even if the bench is hot, answering the question that the judges ask you, and just being, very direct in your answers and not rambling on.
I recall seeing an argument when I was pretty new to the court where both advocates were excellent. And I think what distinguished them was that two things. They came prepared to help the court decide how to decide the case. They knew what they wanted, whether it was, affirming a reversal, vacatur, but they also knew how they wanted the court to get there. And they were able to explain that and articulate that in a way that was really a helpful dialogue between the advocates and between the advocates and the bench. And they also were both prepared to answer each other's arguments. And so it was just a highly effective and very useful argument. And, if we awarded winners based on who argued the best, they would both win. But of course, that's not how we decide.
They're not ties in Fourth Circuit decisions. Judge Diaz, any insight from you about a particular argument that you found effective?
Not in particular. Judge Rushing's description, I think, is a good one. You know, every advocate has a different style and tenor and tone, and you should obviously be true to yourself. I think that's important, whatever you do. You know, generally, the most effective advocates are the ones that understand that this is not an opportunity to make a speech, but an opportunity to address concerns and questions. And I think you're going to get to that here in a moment. You know, because we do, all of us come into the argument if with at least some tentative views, but some concerns about the case. And the really effective lawyers are the ones that understand that really getting to those concerns are what the argument is about, and avoiding them is not going to get you anywhere. So that's, you know, the most effective advocates are the ones that recognize that dynamic.
And to the panel, do folks find it helpful to cross-reference other judges' questions, and especially knowing that this is the first time that the judges on the panel are likely hearing each other's views through their questions? Is it helpful to cross-reference, you know, as Judge Benjamin asks, here's an answer in response to a question that perhaps Judge Rushing asked?
That actually happens quite often, and as I think it's a dynamic of the fact that, as Judge Rushing and Judge Benjamin have mentioned, we don't generally talk beforehand. And so when we hear our colleagues speak, it sort of sparks, in my mind anyway, it does often spark a follow-up question. And I've seen that happen quite often in arguments. And, you know, for an advocate, I think you shouldn't take that as some sort of an insult or an offense that we, you know, diverted our attention away from you. We may have, but it's for a purpose, and that is hopefully to get you to respond to the concerns that all of us apparently are having in the case. So you should, a good advocate will pick up on that and eagerly engage with those questions wherever they come from.
So in our little bit of time remaining, I want to talk about what happens after oral argument. There's something else that's unique to the Fourth Circuit, and one of the things that makes the culture in the Fourth Circuit so lovely. So Judge Benjamin, what happens immediately after advocates finish their oral arguments?
Well, and it's always interesting when I've gone to trainings, and the one question that I always get is, do you all still walk down and shake the hands of the advocates before you? And the answer is yes. And so that is something that is unique to the Fourth Circuit that usually happens immediately afterwards. And then when we finish with the all of the arguments, we go back into conference.
And can you describe what happens in conference?
Well, you know, it depends on the panel. That's one of the things that probably surprised me the most. You have some panels where there's very little discussion, and then there's other panels where we get into discussing the issues, but it's not. But I will tell you that conference is not as long as I probably expected coming onto the court. I find that the judges usually communicate the most during the drafting of the opinion.
And this is a question for anyone. How does the drafting of the opinion process work in your chambers? And how do you use your clerks? What's your process for drafting opinions? Maybe we can start with Chief Judge Diaz.
Sure. So for me, in just about every case, I begin with a draft of an opinion that's prepared by the law clerk who was assigned to the case. And we work off of that draft. And to the extent that I can, I get all the other law clerks engaged in that process if they're not otherwise disqualified or the like. And it's a very, you know, interactive process. We can easily go through 20, 25, 30 drafts before I think that an opinion is in sufficiently good enough shape to then circulate to the panel and the court writ large. The great thing about the court and the size of our court is that with 15 judges, it's a bit of a sweet spot where it's big, but not too big that we can't circulate published opinions to the entire court and seek comment. And we do that, particularly with respect to published opinions. Every member of the court has an opportunity to weigh in. Obviously, the panel engaged with the case is principally engaged with it. And so you'll get most of the comments from the panel. But it is a very interactive process and one that I very much appreciate.
Great. Well, one final question as we close off this section of the presentation. It's been said that the most effective advocates are those that make a judge's job easy. So are there any tips on how an advocate can accomplish that? Can start with Judge Rushing.
Well, my tip is always get to the point. In your brief, get to the point. At argument, stand up and tell us what you want and why. If you get to the point, that is helpful for judges. That makes it easy. So as Judge Diaz had pointed out earlier, it takes some time to figure out what the point is in some cases. And if an advocate puts that time in and then they're prepared and ready to help the judges get there, I think that's very valuable.
Well, I want to say thank you so much to the panel here. It is truly an honor to be able to turn the tables a little bit and have you all answer questions about how things work in the Fourth Circuit. This has been an invaluable experience. And with that, I'd like to turn it over back to Nikki.
Thank you, Michelle.
Thank you.
Thank you so much for leading that really interesting discussion, Ms. Callan. And thank you for your time and your insights, Chief Judge Diaz, Judge Rushing, and Judge Benjamin. I would now like to welcome the members of our third panel to join me. Our third and final panel this morning concerns agency appeals in the Fourth Circuit and is being moderated by Professor Allison Orr Larson. Professor Larson is the Alfred Wilson and Mary I.W. Lee Professor of Law at the William & Mary Law School, where she also serves as the director of the Institute of the Bill of Rights Law, which focuses on educating the broader public concerning the Bill of Rights. Since joining the faculty at William & Mary in 2010, Professor Larson has received numerous awards recognizing her dynamism in the classroom, including an Outstanding Faculty Award, Virginia's highest honor for college and university professors. Her scholarship explores how information dynamics affect both legal institutions and the development of the law. Her work on fact-finding the Supreme Court in particular has been featured in numerous national publications, and she has been invited to testify before both the Senate Judiciary Committee and the Presidential Commission on the Supreme Court. I'm also pleased to add that she's an alumnus of the Fourth Circuit, as she started her career by clerking for our own Judge Wilkinson. Indeed, I know here in Baltimore, Judge Niemeyer remembers her well from that period and always reads her clerkship recommendation letters with particular attention. Professor Larson, I'm delighted to turn the floor over to you.
That is great news. Thank you so much, Nikki. And I'm really delighted to be here. As you mentioned, I consider myself part of the long extended family of the Fourth Circuit. I guess I'm allowed to say that. So it really is an honor to be back. Our topic today for our final panel is agency appeals on the Fourth Circuit. And you would be forgiven if you thought, that's weird because all appeals in federal law go to the DC Circuit, right? I know that some of my students think that, but it's not the case. There are a surprising number of appeals from administrative agencies that show up on the docket for the U.S. Court of Appeals for the Fourth Circuit. So our goal for the next hour is to talk a little bit about the ins and outs of those appeals, what's unique about them, which issues recur, and some pitfalls maybe that are good to avoid. And to do that, I have a panel of three experts that I really am happy to welcome. The first face is probably familiar to you, Nwamaka Anoe. She is the clerk of court here at the U.S. Court of Appeals for the Fourth Circuit. She's fairly new to that role, but not new to judicial administration, to court administration generally. So we're delighted to have you here to give us some insights about the nuts and bolts of these appeals. And then I also have joining me Chris Dunn. Chris Dunn is a staff attorney in the Office of Staff Counsel here on the Fourth Circuit, and he has a specialty in that office. He specializes in petitions of review for agency immigration decisions, and he's going to share some insights and some resources that we have inside the family, inside the House of the Fourth Circuit. He's going to share that with us today. And last but not least, I have John Grimm. John is a partner at Goodell, DeVries, Leach & Dunn, which is in Baltimore, Maryland, where he practices in the firm's commercial litigation and appellate practice groups. And John is going to give us some advice on the practice of administrative law here in the Fourth Circuit, what to do, and importantly, what not to do. So that's our agenda for the next hour. We're happy that you're here. Nwamaka, let's start with you. Can you give us a lay of the land a little bit and tell us how many Fourth Circuit cases are appeals that come from an administrative agency? How many are we talking about?
Sure. Thanks, Professor Larson. So over the period of the last 10 years, we've received about 200 to 300 appeals directly from administrative agencies. The number represents 4.5% to 8% of our caseload, but again, it depends on the number for each year. It's fun fact, the immigration cases that we receive, it's about 70 to 80%. And immigration appeals accounts for 5.5% of our filings in FY 2023. It's a number that's higher than most people expect. But fun fact again, in every circuit, the majority of agency appeals that we get are from the Board of Immigration Appeals. This past year, surprisingly, we had more than the 11th Circuit, and we were a close second after we came behind the 5th Circuit. Of course, the largest circuit that always gets the majority of immigration appeals would be the 9th Circuit. So our numbers are a drop in the bucket compared to what they have. They have 1,922. We had 203 filings. So we received approximately 5.6% from the Board of Immigration Appeals. We also get a fair amount of appeals from the Benefits Review Board, stemming from denials of Black lung benefits in West Virginia. So it's often our second largest source of agency appeals. But if we look at it, Social Security would be second, but it comes from the district court. So for FY 2023, for the cases that came from the Benefits Review Board, it was about 45% of the appeals from there. And there was a sharp increase in 2023, but that was only because we had 27 related cases that were filed by Eastern Associated Coal Companies, Coal Company and Peabody Coal. So we had a spike in 2023, but that's not the norm. So that's just a rough.
Yeah, that's significantly more than I would have thought. So that's really interesting. Can you tell us what happens to these appeals once they're filed? Like, where's their first stop?
So of course, filed in the clerk's office, and we go through our process. We'll use the immigration one as an example. If a petition for review is filed, and we're going to go down two paths. If a motion for stay of deportation is filed at the onset, we immediately issue a 10-day administrative stay order. And then every single emergency motion that we receive, we route it to the panel for a decision by the court. Once that happens, it follows the regular path that just the petition for review would follow if it was not accompanied by a motion for stay. So when we get a petition for review, we issue a docketing notice, and counsel files their appearance, of course, and then we would expect the disclosure statement followed by docketing statement. Once we get that, the clerk's office issues a notice requesting the record. And once we get the record, we will then issue the briefing order. Once that happens, the time that we have for most cases is waiting for the opening brief to be filed. And sometimes we have motions for extension of time within which to file those. Same thing happens with the response. So it's just in that period. Anything can happen during that period. Other motions could be filed. But if it's a straight case where the briefs are filed, the counsel to the clerk reviews the briefs, and she can either send it for calendaring, or if it requires an in-depth review, it's sent to the Office of Staff Counsel. Chris can speak later on what they do, but that's where we are with just the initial cases that are filed and what we do with it.
Okay, that's a good transition to you, actually, Chris. Can you tell us, so we now have the first stop, we're moving into the second stop. Can you tell us a little bit about the role of the Office of Staff Counsel in these administrative appeals? Let's talk generally first, and then we'll move into immigration specifically.
Sure, thank you. The Office of Staff Counsel were considered the central legal staff of the Fourth Circuit. There's about 25 attorneys. There's 2 senior attorneys. There's several supervising attorneys, and there's also an administrative staff that supports the work that we do. So when the Office of the Clerk sends a case to us, it is then distributed to one of the staff attorneys in the office. That staff attorney would then look at the record, look at the briefs that have been filed, prepare a memorandum, and then and a proposed recommendation, and then the case is then submitted to a 3-judge panel. As you heard in the prior session, about 80% of the counseled cases are decided on the briefs, are not argued. So those cases that are decided on the briefs are most likely coming from this office. With an agency appeal, because it deals with a very unique part of the law and a unique set of regulations, there are several people here in the office who have gained an expertise in that area of the law, whether it be a Social Security case or a Benefits Review Board case or an immigration case. There's 4 of us here in the office who will handle the immigration cases. We've gained our experience either by doing something in private practice before joining the Fourth Circuit, or as in my case, the expertise was gained on the job, just learning from the very beginning how to do it. We'll also handle, as Namaka mentioned, some, but not all, some of the motions for stay that are often filed with the petition for review. So we may handle some of those as well. Those are also on a deadline because the advocate wants to make sure their client is not removed to the country they've been ordered removed to. So we'll get those out of our office quickly to 3 judges to issue an order.
Just a quick follow-up, and then we'll move to immigration. Is an appeal from an administrative agency any more or less likely to be decided on the briefs, like in your experience?
More, in my experience in immigration cases, I can't really speak to Social Security cases or the Benefit Review Board cases. In my experience, most of them are decided on the briefs, yes.
Interesting. Okay.
Yes. We'll
so
decide if there's an issue. We'll look at the briefs and we'll be able to identify perhaps an issue of first impression, or an issue over which we have no published opinion, or an issue of public significance, and then we'll be able to refer it back to the calendar and have it argued by one of our panels.
So let's talk a little bit specifically about those immigration cases, since that's
Sure.
a specialty of yours. I think it might come as a surprise to some of our viewers, the numbers that Namaka gave us that are pretty significant. 70 to 80%, she said, were immigration cases. So of those cases, what are the most, like, the reoccurring issues? Like what seems to be like patterns that most often present on the docket from those cases?
Sure. I'll presume that most of the people on this webinar have not represented a person before this court in an immigration case. So maybe if I could take a back step and just define what an immigration case might be in the typical situation. Typical situation that we face is someone enters the country either illegally without being inspected at the border, or they enter the country with a visa and they overstay their visa, or again, in the first example, they're here illegally. The Department of Homeland Security will issue them a notice to appear, which is a charging document, which will charge them with removability, that they need to be removed because they don't have permission to remain in this country. Most of those charges that they're here illegally are rarely contested. Most of the persons here illegally who say, yes, that's me, I am here illegally, or I overstayed my visa, but they say, I don't want to go back home. I'm going to be persecuted, or I'm going to be tortured. So then they might apply for asylum, or its related relief, withholding of removal, or protection under the Convention Against Torture. In that case, they'll have a hearing before an immigration judge in an administrative agency. They'll be able to present evidence. They'll be able to take the stand and tell their story. They'll have an attorney, not at the government's expense. They'll have one that is usually retained, or someone doing pro bono. And then if the immigration judge decides against them, they'll appeal that decision to the Board of Immigration Appeals. And if the Board of Immigration Appeals affirms the immigration judge's decision and dismisses the appeal, they'll then file a petition for review from a final order of removal, which is what the board's decision is called. They'll file a petition for review from a final order of removal in this court. And just to give a little bit of context, so Maka gave the numbers of the number of cases we have in this court. Currently, pending in immigration court are over 3 million cases. According to Syracuse University, which keeps a record of this, there are over 3 million immigration cases pending before immigration judges across the country. That's a jump of 3 times since 4 years ago, about 2020, when it might have been just 1 million cases pending. Such a tremendous backlog of cases. Most of those persons are applying for asylum. About 70% of those persons will be denied. And then they'll appeal that denial to the board, and most likely that appeal will be denied. And then they'll come here to this court, or one of the circuit courts. So by statute, you will file the petition for review in the judicial circuit where the immigration judge heard the case. And that's how it ends up in this court. We have immigration courts in Maryland, Virginia, here in Richmond, and in North Carolina. But one of the traps might be a case that we decided in this court just a couple of years ago, and probably brought on by the COVID-19 pandemic, when many of the hearings, the immigration hearings, were done by video conferencing and not in an immigration court. So the non-citizen who's applying for asylum might be in a detention center in Farmville, Virginia, but his immigration judge might be in Louisiana. So the question might be, where do you file the petition for review? Do you file it in the Fifth Circuit? Do you file it here in the Fourth Circuit? Well, our court decided, and it's not necessarily the opinion shared by the other circuit courts, our court decided that you submit the petition in the circuit court where the immigration judge was sitting. So in that instance, you would sit it in the Fifth Circuit. In the instance, in that particular case, the tables were reversed. The non-citizen was in a detention center in Louisiana, but the immigration judge was in Falls Church, Virginia. So the venue, that's perhaps the first trap, is where you're going to file your petition, and choosing the right venue saves a lot of time. Another trap that occurs is, when do you file the petition? And that would be within 30 days of the final order of removal by statute. And that is jurisdictional and not subject to equitable tolling. So that sounds pretty cut and dried. In fact, we have dismissed many cases where the petition was filed 1 day late, on the 31st day. It was sent by FedEx. FedEx might have lost it, and delivered the petition later than you imagined, and so we will end up dismissing that petition for review. We have a percolating issue on that, and almost like breaking news. In the case that we decided in November, Martinez v. Garland, if I can get into the weeds just a little bit, the petitioner, Mr. Martinez, was ordered removed from the United States back in 2019, and was actually removed. He re-entered the United States in 2020. He was found by the Immigration Service, was issued a reinstated order of removal by the immigration officer. So in other words, that prior order of removal was resurrected and given to the non-citizen, said, you're going back because we have the order of removal. But Mr. Martinez said, wait a second, I can't go back. I'm going to be tortured and persecuted by the gangs. So the immigration officer then referred him to an immigration judge, and he got to say his case of why he can't go back. It's called a withholding only proceeding. And then he lost his case before the immigration judge. He appealed to the Board of Immigration Appeals and lost his case there. And his attorney filed a petition for review 30 days within the 30-day period after the Board of Immigration Appeals issued its decision. But unfortunately for Mr. Martinez, this court ruled we did not have jurisdiction in that instance because we only have jurisdiction over final orders of removal. And the final order of removal was issued when the immigration officer issued him 2 years earlier the reinstated order of removal. So we found that we lacked jurisdiction in that instance, and the case, of course, was dismissed, and Mr. Martinez didn't get an opportunity to hear the case in the merits. But yesterday, Mr. Martinez filed a petition for rehearing en banc. Not unusual, happens frequently. But this is what also happened yesterday is the government also filed a petition for rehearing en banc. So both parties weren't too crazy about this particular decision. And in the government's petition, they're arguing that this 30-day period that I have been referring to is not jurisdictional, even though it has been considered jurisdictional for years. They're arguing that it's not jurisdictional. And the second thing they're arguing is there are particular decision in this case where we told Mr. Martinez that his 30-day clock started 2 years ago, that was just wrong.
So stay tuned. Inquiring minds want to
Yes, breaking news.
Okay, John, let me turn to you and ask a couple of questions, and then I want to make sure I invite our audience to ask their questions. But let me ask you mine first. So in your Fourth Circuit practice, John, what administrative law issues are the most common? So let's start there, and then we'll talk about things to avoid.
Sure. So, I think that I'll go a little bit broader and make it my administrative law experience, not necessarily limited to the Fourth Circuit. Obviously an agency, the sort of traditional model is that an agency can either do a rulemaking or an adjudication. So at the fundamental level, you're either challenging an agency's decision in a adjudicatory case, which would be like, for example, the removal proceedings or the issuance of a license or things like that, or you're challenging a rulemaking where the agency put out some sort of policy. The issues on the merits are usually in some ways sort of all fall into the same category of issues because there's specific bases for review that the Administrative Procedure Act allows. So you're usually arguing about whether or not the agency, in an adjudication, if there was sort of substantial evidence to support the decision, if the agency failed to consider a particular law or made a legal error, if you're challenging a policy decision by an agency, was the agency acting arbitrarily? Did the agency, did they ignore important issues? Is the policy sort of the result of a process that didn't follow the requirements of a rulemaking proceeding? So the issues themselves can the sort of bases of review are generally going to be quite similar, although you often get into some complex issues of agency deference. Did the agency apply the statute correctly? Is there prior agency rulemaking that contradicts the later decision? Things of that nature. And then I think that where, and those are all, merits related issues that, you can fight over once, you get to court and get to the briefs. I think that the more particular pitfalls that people, often encounter are the ones that kind of keep them from getting into court in the first place. And I know that's kind of where you're headed next, but, some of the thorniest issues, have already been overcome by the time you get into court and are, able to sort of, safely get to the merits, knowing that your case has already been, docketed.
So for the average Fourth Circuit litigator who doesn't typically litigate on either, attacking an agency appeal, what advice? What would be your first piece of advice? You might not know this, but make sure you fill in the blank.
Yeah, so I think the most important thing that anybody with an agency appeal needs to do, sort of, at the earliest stage, is figure out what is the relevant body of law, not just for how the agency that you're challenging operates, but for, what is your mechanism for judicial review. We're talking about agency appeals, and that is, a colloquial way that we refer to them. But the reality is they're not actually appeals where you file a notice of appeal with the district court and then the record gets forwarded on to the circuit court. An agency appeal is actually a new proceeding. It's an original jurisdiction. It's the court's original jurisdiction reviewing the action of a different branch of government. And the reason that matters is not just pedantic. It's because for every appeal, and I'm using the term even though I just said that's not what it is, but for every appeal of an administrative agency, there has to be some statutory authority that says this is how you get into court. The caveat to that is that sometimes you can, sometimes there doesn't have to be, but that's a separate matter, because that, you can sort of, failing anything else, you can file a declaratory action in the district court, but that's not really what we're talking about here. The courts of appeals need to have, there needs to be a grant of jurisdiction for the Court of Appeals to hear an agency appeal. And unlike in the case of district court review, where it's a uniform process, you have a certain amount of time to file your notice of appeal. The rules governing the Courts of Appeals jurisdiction over agency proceedings is really a patchwork, and it can be almost a scavenger hunt to figure out the mechanism and the procedure to get into court. I was looking around in preparation for today's presentation, and Judge Heitens told us that the major appeals that the Fourth Circuit hears are immigration appeals and NLRB appeals. I was able to find the time frame for filing an immigration appeal pretty quickly, and I'm still trying to find the statute that says when you file your petition for review in the other kind of case. There is a statute confusingly called the Hobbs Act, which is not the sort of fun and exciting Hobbs Act that we're used to, which is the administrative, review statute that gives the Courts of Appeals jurisdiction over some agency decisions, but not all of them. And, if you're, so some agency review is going to be governed by that statute, and it's going to have one set of requirements. If not, you might have to look elsewhere. And one sort of, the example that I see a lot is decisions by the Federal Communications Commission. Most of those can be filed within 60 days in any Court of Appeals, but a subset of FCC decisions have to be filed within 30 days and can only be filed in the DC Circuit. So that's a very easy way to blow past a jurisdictional deadline and lose your appeal before it even gets started. So, and I've seen, some agencies, you can file something within 90 days. It's often 60 days, although we've also heard today that it can be 30. So you really need to know where you are able to file your appeal and when you have to file it, because and it almost has to be determined on a case-by-case basis, unless it's just something that you have done so many of them that the rules are just sort of internalized. And then even within those parameters, there can be additional issues. And of course, I should step back. I'm not even, getting into some of the prerequisites to filing, like, do you have a final appeal, a final decision by the agency? Have you exhausted all your remedies? Those are whole bodies of law that, I'm sort of assuming that you've, satisfied all your, exhaustion and finality requirements. Then you have to figure out where you go to court. But then sort of one additional, potential thing that people need to be aware of is, depending on what type of agency action you're challenging, suppose you have a client in a heavily regulated industry, and there's a new regulation that affects you and you want to challenge it. Often there will be multiple petitions for review, and sometimes they'll be filed in different courts. That could be done based on a tactical preference or just a geographic preference, but it's not unusual to see, a particular agency decision challenged by one party in the Ninth Circuit, one party in the DC Circuit, and maybe one party even in the Fourth Circuit. When that happens, there is a process by which the judicial panel on multi-district litigation, which we typically think of as the panel that creates multi-district proceedings, well, they also handle multi-circuit petitions for review, and they run a lottery. They basically draw a court. I don't know if it's actually out of a hat, but they pick a court at random and consolidate all of the petitions for review. So the rub there is the lottery is run after 10 days of the first petition being filed. So you may have a 60-day filing window, but if someone else files a petition for review and you want to maintain your chance of having your court compete in the lottery, you need to get your petition filed within 10 days, not within 60. You're not going to lose your appeal if you do it, if you miss that, but you might lose your forum of choice. So, it's such a patchwork to know, so you really need to be precise about, what is the specific decision I'm challenging. It's not even enough to know which agency, sometimes it's which type of decision by this agency. What is the statute that gives the court jurisdiction? And if you can't find it, find it. You have to figure out how to find it, so, call people, Google it, spend hours on Westlaw, whatever you need to do, because it really can be a thicket trying to figure out, something that you would think is basic, and, so just don't leave those kinds of things to the last minute, because that could be very significant to your ability to actually pursue your case.
Word to the wise. So I have more questions of my own, but I'm going to pause here for some questions that came from the viewers. The first one is for you, Nwaka. When a case arrives in the clerk's office, how do you all determine whether it warrants oral argument?
So we basically use, we do the review, first of all, to find out. Chris mentioned it earlier, is the same process that they look at. Is it a case of public significance, or it's so we follow the same criteria on the face of it. It's only if we're not sure and we feel that it requires an attorney to do an in-depth review, that's when we will send it to the OSC.
Mm-hmm. So then, Chris, I have another audience question for you, actually. So when the staff attorney's office reviews a motion for stay of removal in an immigration case,
Mhm.
do they then make a recommendation to the panel, or do
Yeah.
they just summarize the issues for the panel?
We make a recommendation based on the standard, which is similar to the standard for a preliminary injunction.
Terrific. Now I have a question for you from me,
Sure.
which is, are there any resources that perhaps our audiences might not be aware of that where they can tap into some of this expertise that your office possesses, particularly in the details of these immigration appeals or the pitfalls that John was talking about? Is there any place to go? Help from within the house?
I think I'm thinking of there are several, probably in every large community, there are immigration rights centers, and they deal, and many of them will assist non-citizens in that area in proceeding with an asylum application or another application so that they can remain here in the United States. In DC, there's the Capital Area Immigration Rights Coalition. I know here in Richmond, we have one, something similar. So that might be a place to begin where you might learn some of the pitfalls that John was describing or that I was describing, when to file, what to say, how to get your foot in the door first, because that is the most important thing. And then there are, well, I just found online resources. Syracuse University keeps a record of all the numbers of immigration cases, where they're most likely to fall, how many succeed, how many fail, year to year. So if you want that kind of statistical information, Syracuse University does that. And I know that there are not-for-profit NGOs out there that are keeping this information and keeping a record of different issues, different arguments, and how they handle it. Unfortunately, I can't give a specific one at this moment.
That's all still helpful, though. Thank you.
Sure.
So I actually teach administrative law. I have 100 students this semester because it's a very hot topic. And it's almost as if the Supreme Court justices don't care about my syllabus because they keep issuing big decisions that change what I'm going to cover. I mean, it's like almost they don't even care about me. So I want to know, John, let's start with you. How do you think if there's big changes still to come, like particularly with the Chevron decision, the Loper-Bright decision, how will that affect practice in front of the lower courts, particularly the Fourth Circuit?
Sure, and I, sympathize with your sort of shifting syllabus. I'm doing a presentation this summer for the Maryland State Bar Association, and I've titled it all about administrative deference, if it still exists, because I don't even know what the law will be at that time. I think that well, I don't want to say obviously, because I don't, think everyone is as immersed in these areas, but the big issue this term is Chevron deference. The court recently heard arguments in two cases that were urging it to repeal the Chevron doctrine, which, for those who aren't, fully steeped in these issues, Chevron deference, I think, is a topic that has kind of made its way into the public mainstream to some extent, but the way it operates is, at bottom, it's a rule of statutory interpretation, and it says that when an agency is interpreting a statute that it is charged with administering, so the FCC administering the Communications Act, but not the FCC administering or interpreting, say, the Clean Air Act, for example. If the statute's ambiguous and it's the statute that the agency is supposed to be interpreting, courts will defer to a reasonable interpretation by the agency. So that obviously puts a lot of power in the agency's hands, because they essentially make, they can essentially make conclusive rulings on what a statute means. And some later Supreme Court cases have even extended that to the point where an agency can make a binding interpretation after a court has made one, and you can effectively have an agency reversing a court decision. So there has been a lot of criticism about this doctrine, and a lot of commentary, and even writings by some of the current justices suggesting that they view this notion with some skepticism. And so I think that the general consensus is that this term, the court is likely to overturn Chevron. I don't know that I think anyone is really expecting that they will not overturn it. And so I think what that's going to do is create, a little bit of a decisional vacuum in the lower courts until courts kind of figure out what you replace it with, because obviously, it serves a purpose, which is it's an aid to courts in interpreting ambiguous statutes. So I think that there are there's a couple ways that I sort of think that this could play out. One, and I think it helps to kind of keep in mind that there's sort of two explanations that you hear for the Chevron doctrine. One, pragmatic, and it's just agencies have subject matter expertise, and if there's sort of an unclear issue, it makes sense to defer to them because they're the experts. Then the more sort of normative explanation is, well, Congress intends the agencies to have the power to sort of fill in the gaps in their statutes. And so when statutes don't spell something out completely, it's because Congress expects the agency to fill it in on its own. And I think that those different views kind of lead to different outcomes depending on what happens. So as a practical matter, courts are still going to be confronted with questions involving the interpretation of involving agencies' interpretation of statutes. And if there is no more Chevron deference, courts are still going to have to figure out what these statutes mean. They'll employ other principles of statutory interpretation. And there is a form of agency deference called Skidmore deference, which basically, I don't really know that it's even deference, because it's just, if we find a argument persuasive, we'll follow it, which is just sort of always the case if a court finds an argument persuasive. So I think that as a practical matter, courts are still going to be likely to defer to what the agencies say the statute means, because the agencies still have that expertise. It'll just be more of a discretionary type of review. But what's going to be potentially more significant is if the reversal of Chevron, kind of coincides with the rise in a related doctrine that we've been seeing called the major questions doctrine. And this is the notion that, when agencies are acting in an area that, has just really, really major, nationwide scope, and there's not sort of a clear definition of when it applies, but basically when agencies are enacting really significant nationwide policies, courts are starting to look for a clear expression of congressional authority for them to do this. And so I think that, in repealing Chevron, if the court sort of rejects this notion that Congress intends for agencies to fill in the gaps in their own statutes, that type of holding, combined with the sort of increasing prevalence of these major questions holdings, might mean that lower courts are going to find themselves having to really scrutinize not just whether the agency, had a reasonable, understanding of the law, but whether there's, a discernible grant of congressional authority for them to act in the first place. So you could see courts essentially still deferring to agencies, or we could see a situation where courts are have to become much more active in sort of regulating what the scope of agency authority is. And that all is going to have to, it's going to have to shake out in the lower courts. And I think there's going to be a lot of, we're going to see the development of a lot of new, approaches to agency appeals, while courts try to figure out what the new sort of rules of the road are, post Chevron.
So I'll offer my own fearless prediction, which is always dangerous. But if you listen to the oral argument in Loper Bright, there was a lot of concern, as you say, John, about, well, what replaces Chevron? If not Chevron, then what? And Justice Barrett mentioned this idea of what she called Kaisering Chevron. So Kaiser was a recent decision dealing with a cousin of Chevron called Auer deference. And they didn't get rid of Auer deference in Kaiser. They just modified it, giving more room for statutory interpretation to actually, is it really ambiguous, to kind of give a skeptical eye. My prediction is that that's what they're going to do to Chevron, that they're not going to overrule it, but they're going to change it fundamentally, which for the lower courts will mean a lot more statutory interpretation, a lot more aggressive statutory interpretation at step one. So there won't be so quick to find ambiguity. I've been wrong before, but that's my prediction. Okay, I have another question from the audience about Chevron, actually, which is the Fourth Circuit sua sponte holding any agency cases in abeyance pending the Supreme Court decision in the Chevron cases, the Loper Bright case, et cetera? Or will it only do that in advance if a party specifically requests it? Do we know?
To my knowledge, we do not currently hold any cases in abeyance, but with respect to the court sua sponte holding cases in abeyance, they can do that without a motion. But if the court enters an order or issues an order, the parties will be notified that that's taken place.
Okay, well, there you go. A concrete answer to that question. We're reaching sort of close to the end of our time together. Do any of you have something that you would like to add on either of these sort of broad topics, either thinking about administrative appeals, which I know maybe we're not supposed to say that anymore, but administrative appeals for administrative agencies generally, or the immigration one specifically? What would the average lawyer in our audience want to know about it, or what would you like to add?
Well, if I could add something, with 3 million cases pending before immigration courts across the country, if you're thinking of what sort of career path to follow, immigration might be a very good one.
Yeah.
You might have a lot of work.
And similarly, for our law clerks watching, you're going to get one on the docket. It's coming your way, right?
Yes.
It's a numbers game.
Yeah. I mean, that number of, I think Namaka said 80 or something, 80 cases or so, it'd probably be 100, 200 before
3
long.
million divided by 13 circuits. I know it's
Yeah.
not even, but that's still a lot.
Yeah.
What about you, John or Namaka? Do you have any thoughts to add?
No, I don't have anything other than always be prepared.
Always be prepared. Like the book. That's right. Like the scouts.
Yeah, I think that's my advice as well. Just can't sort of stress enough how, you really need to know what the governing law is procedurally of your case. And it's sort of never too early to start thinking about, do you know the rules for how to get into court? Do you know, the rules for whether you've, met any requirements for standing, or, things like that. You should be thinking about those things at the earliest stage in your case.
Yeah, never assume you know, right? No, when you don't know.
Something else
When you
came up.
don't know it.
Yeah. Yes, Chris, go ahead.
Sorry. Listening to the prior panel, where they discussed how they like their briefs. And I think the attorneys here that work on immigration cases, when you cite to a statute, the practice has been historically to cite to the Immigration Nationality Act, but it's very difficult to find a cross-reference to the USC. So if in your briefs, if you're doing an immigration appeal and a petition for review, cite to both the INA and the US Code would be really helpful.
That's very, very good practical advice.
Especially as my eyesight is failing and I'm looking at the CFR and trying to figure out where it is in the book, it would really help.
I remember Chief Judge Diaz said, use bigger font, which maybe is good here.
Would help too.
Oh, I have another question from the audience, actually. So the agency experts in the Office of Staff Counsel, like you, Chris, you sort of mentioned this, but I think more generally, are you hired with that expertise, or do you develop it over time, or a little bit of both?
Both. I developed it over time. I did not do any, I worked in the Second Circuit before I came here to the Fourth Circuit. In the Second Circuit, we did exclusively pro se petitions and occasional pro se motion for stay. Did not do any immigration cases except motions for stay. And when I came here, shortly after, I must have drawn the short straw that day, but I started getting assigned immigration cases. But it's been I say that, but it's been a changing every year. It changes. Something new keeps the mind active, how to respond to something. The court has changed direction. I don't know, has given different opinions about stuff or massaged the law in a different way. So we have to stay up to date on that.
Okay, now the questions are coming fast and furious now from the audience. Do you have any advice for approaching oral argument in an agency case as compared to other type of cases? So we talked about pitfalls, but what about oral argument specific advice? I think we'll go to you for this, John.
So oral argument specific advice, I may kind of punt on that and answer a slightly different question, which is preparing for advocacy before the court. And one of the interesting aspects of agency work, especially if you're talking about like an agency rulemaking proceeding, is that you really have an opportunity to craft the record that you want the court to review. You can file, comments in agency rulemaking proceedings, and then often there are procedures for, going in and having meetings with the agency, putting additional arguments in the record. And often these things get sort of litigated within the agency, but not, you're not really limited to sort of one round of briefing. There are lots of opportunities to submit arguments and get legal points in front of the agency. And so if there are particular issues that you want to be on the court's, you want the court to, on the court's attention, or that you are, concerned you need to strengthen, you have a really good opportunity to develop those before you even get into court. And so, you should be thinking, what will my brief look like when we challenge this rulemaking? And what do I need to do at the agency level in order to make the brief look like that? In terms of oral argument, I wouldn't necessarily approach it any other way, because it's an oral argument like any other, where the court's going to ask you questions and they're, legal questions like in any case. I would note that there can be a real tendency among agency, administrative law practitioners to get really in the weeds with some very inscrutable jargon. And I think that at the agency level can be sort of tolerated because the agency understands it, but you should probably assume that the court doesn't. The DC Circuit will reject a brief that contains too many acronyms. I don't think the Fourth Circuit has a rule about that, but you should, I think it's a pretty good idea to pretend that they do, because you can make a brief unreadable by, relying too heavily on jargon, and it doesn't demonstrate expertise or sophistication. It just makes the brief confusing and hard to read. So a unique challenge in agency appeals is really making sure that you're expressing concepts in plain English. The judges are sophisticated, they'll understand, but the brief will be better if you can explain it in terms that don't require you to be an expert in administrative law to follow.
I always limit myself to one acronym per case when I'm teaching, because I feel like they'll boo me out of that classroom if I start using too many.
Yeah.
I have another question. Actually, this one's for you, Chris, which is, can we get a breakdown of expertise in the Office of Staff Counsel? So particularly, this person is curious about environmental cases, but what sort of expertise do we have in the office besides just you?
It has shifted over time. So there's there's 4 staff attorneys who have an expertise in immigration like I do. And among the other categories, it may just be 2 or 1 staff attorney. There might have been, over time, there might have been one staff attorney who had an expertise in the sentencing guidelines, another staff attorney who had an expertise in black lung cases, another staff attorney who would have had experience in Social Security cases. So although all of us work on all of those areas of law and can be assigned a Social Security case at any moment, there is one person within the office who would be the go-to person. If you have a question, go to that person and say, here's my issue, here's my problem. And but because immigration cases fill the largest of the agency docket, there's the most of us. 4. Yeah.
Interesting. Okay, I have one last question, and this one is a good capstone question. We started talking about it with acronyms, but what is the best practice when you're dealing with highly complex administrative cases, particularly immigration cases? And specifically, are there tips for consistency and efficiency in briefs? So we've learned, 1, don't use too many acronyms, don't be too specialized, remember who your audience is. I think that's maybe the most important piece of advice. But is there any other advice to, like, the best practice in arguing these highly complicated cases to the court?
As I said earlier, cite to the USC rather than the INA.
USC.
This is very important. Makes it easier for us to track down the statute you're referring to. And that does make a lot of difference for us that are working on this.
All right, cite to the USC. Don't use too many acronyms. Use a good font, big font. John, what were you going to say?
Don't overlook the sort of basic fundamental legal points, like, there is such and such an agency, it exists, it does the following, it put out this rule. People who practice before a particular agency often, I think, have a tendency to sort of lose perspective of what kind of introductory information someone needs in order to be able to follow it. I often find that when you're writing the brief, you kind of want a combination of people who know how the agency operates very well, but also generalists whose role is just writing clear briefs on whatever the topic might be, because there's a lot of sort of translation into plain English that takes place. And so it's, I always try to write for, an audience who is, sophisticated and very capable at understanding the law, but assuming that they don't sort of have any of the background law necessary to understand the particular issue, and then making the brief sort of walk them through that so that when you get to the issue, it's something that they have no trouble following.
Yeah, I always tell my students, first, above all, you're a communicator. And I think that is particularly important when you're dealing with administrative law and highly complicated material. So we have reached the end of our time together. I just wanted to say thank you all so much for joining me this morning. I learned a lot personally, and I'm sure our audience did too. And Nikki, the floor is yours.
Thank you so much, Professor Larson, and thank you, Mr. Grimm, for joining us. I, for one, would love a rule that would allow us to reject briefs for excessive acronyms, so we may have to look into that. And I want to thank Namaka and Chris as well for sharing that really unique behind-the-scenes look at the court's operations. I have to have just a few final things to note before we conclude today's program. First, at the conclusion of the session, a survey will appear on your screen and be emailed to you. We would really appreciate it if you would complete the survey, as we're putting on this program as an attempt to be a service to the bar. And so any feedback about how we can do that more effectively is greatly appreciated. Second, we have recorded today's webinar and a copy will be posted on the court's website next week. Finally, just to repeat from before in terms of CLE credit, the court will provide attendance records directly to the state bars in North Carolina, South Carolina, and West Virginia. If you indicated that you will be seeking CLE credit in Virginia, we will email you a certificate of attendance that you can then use to certify your attendance on the Virginia State Bar's website. For all other states, it will be necessary to self-submit. And with that, Chief Judge Diaz, I believe I can turn the floor over to you for a final time. Thank you very much.
Thank you, Nikki, for your wonderful turn as our host this morning and afternoon. A special thanks to all of our outstanding panel members for the insightful and informative and just all around great work that they've done, obviously, in preparing for this webinar. I think it was quite informative and helpful, and I hope our audience agrees. Obviously, something like this, a project like this, doesn't happen by magic or happenstance. It takes a great deal of work behind the scenes. And I want to especially recognize the members of the core committee of folks who put this program together, beginning with my friend and colleague, Judge Toby Heitens, who served as our chair and whose vision inspired this program. Gretchen Hall, who you met earlier this morning, who was instrumental in making sure the trains ran on time. Our IT folks, Jamie Storm and Jackie Quella, and all the other IT individuals at the circuit who do a great job on this program and do such great work for us day in and day out. Our clerk's office, Wamaka and Mark O'Brien, our deputy clerk, and all the members of the staff of the Fourth Circuit who make us look good each and every day. You know who you are. If you were involved in this program, you have my great thanks and gratitude. And so on behalf of the Fourth Circuit and my colleagues, thank you all so very much for joining this program, and take care, everybody. Have a wonderful weekend.